Good morning, sir.
Pardon, meeting is held on? Meeting is to be held. 9/6. Yes, problem. What is the issue? No, what is the issue? What is the issue? 15 days notice is given. Whom do you represent? Request of the council for petition. When do you want it? When do you want it? There's a calendar is set up there. When do you want it? You should come up with a date. Huh? 30th. Hmm. Hmm. At the request of the council for in the fourth zone. Hmm. Yeah, what is the issue? Is it? Huh? The request of the council for petition and list on 7th June. The number? The request of the council for petitioner. When do you want it? 52. What's your name? The MS Devraj accepts notice for the respondent number 4. Office is directed to show the name of Mr. MS Devraj. The relevant counsel for the petitioner is directed to serve copies of the petition to the relevant counsel for the respondent number 4. Next, at the request of the counsel for the respondent petitioner, list on when the date of 8th June. Forty-one. Here is the ULC. Whatever the request of the council for petitioner, the date of price. List on 9. Put objection ready. Put it. Partharala banda put it. It was listed yesterday, Mr. 47. The request of the council for respondent is on 7th June. Please intimate the other side. Yes. Any request?
Item number 45.
Pardon?
Item number 45. Appear for petitioner, Your Honor. Praise for 1 week time.
In this case, I appear for respondent, my lord. I have no objection.
Obviously, 2014 people understand.
Serial number 37, my lord.
Petition is pending from last 8 years. You people say.
Advocate to represents or 14%.
Serial number 37, a week may kindly be granted.
Request of the council for petitioner and respondent. Command list on 8th June.
Serial number 30, my
Serial
lord.
number 37, my lord. ಅದರಲ್ಲಿ amended petition ಹಾಕ್ಬೇಕು ರೆಡಿ ಇದೆ ಹಾಕ್ತೀನಿ ಸಮೇತ.
The request of the council for petitioner list on. When do you want it?
Any day may go for.
Any date? You please pick a date.
31st, my lord. 31st or next week.
31st.
Much okay.
Serial number 6.
Serial number 30, my lord.
Number
30. 30. I am for the petitioner, my lord.
that's in the order list. Wait, please wait. Yes.
Serial number 65, my lord. A paper respondent number 3. Kail next week any date. 1ನೇ ತಾರೀಕು ಆಗಬಹುದು ಸರ್. Yes.
The 2012 matter.
ಹೌದು ಸರ್, ಇಲ್ಲ ಸೀನಿಯರ್ ಇವತ್ತು ಪರ್ಸು ವರ್ಕ್ ಮೇಲೆ ಬೇರೆ ಕಡೆ ಹೋಗಿದ್ದಾರೆ. ಮೊನ್ನೆ ಇದ್ರು ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಪಿಟಿಷನ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಲಿಲ್ಲ ಮೊನ್ನೆ ಸರ್. ಮೊನ್ನೆಯಿಂದ ಇವತ್ತು ಬಂತು.
The request of the council for respondents.
1 or 2 ಯಾವತ್ತಾದ್ರೂ ಆಗ್ಬೋದು. 2ನೇ ತಾರೀಕಿಗೆ ಕೊಡಿ ಸರ್.
Just on second.
Please.
Second.
Please.
My lordship, serial number 54, my lordship.
Hmm.
I pray for a week time, my lordship.
Whom do you represent?
Appearing for the petitioner, my lordship.
The learned counsel for the petitioner seeks time. 54. When do you want?
Any date after next week, my lordship.
Okay, you please tell any
8th or
date.
9th, my lordship. 8th or 9th, my lordship.
8th of June.
Much obliged.
Serial number 30, my lord. 30.
30 it's in the orders list, mister. Please wait.
serial number 33, my lords. I am for the proposed respondent number 4, my lords. Counsel is unwell today, my lords. Your lordship may have
Please
it on
wait.
next week, my
The
lords.
orders list, please don't make a mention in the orders. Yes. Correct. So, Giri Kumar.
For petition.
Yes, please.
There is, we are all the siblings, my lord. We are all siblings, and in a joint family, my lord, there is a will and bifurcation, my lord. Kata transfer request was made in the year 2015, which is at the annexure C, my lord, page number 19, my lord, and endorsement is issued by the respondent, stating that there's a civil. You go before the civil court. All my lords, kind consultation is that let them examine my papers and take a decision on the matter. That is all my request.
Based on the will.
Yes, ma'am.
There is a full bench judgment of this court.
Please, ma'am. The authorities have not examined my documents. Let them examine and take a decision. That's all.
There is a question of examining your documents, Mr. The will has to be proved. Based on the will, can the authorities decide whether you are succeeded to the property or not? That is the judgment of the full bench of this court. ILR 1997.
In alternatively, my lord, I will approach the authorities, my lord. Regional commissioner has the power to re-examine the.
Are you claiming revenue records based on the will?
No, my lord. It is on the basis of the various documents, including will, my lord.
Please read Annexure C, page 19.
Yes, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಉಲ್ಲೇಖ ಅರ್ಜಿದಾರರು ನೀವು ದಿನಾಂಕ 4/6/2015 ಆರ್ತೆ ಕ್ರಮ ಸಂಖ್ಯೆ 1358/951 ಸ್ವತ್ತಿನ ಹಕ್ಕು ವರ್ಗಾವಣೆ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಮೇರೆಗೆ ಈ ಕಚೇರಿ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ನೀವು ಹಕ್ಕು ಬದಲಾವಣೆಗೆ ಕೋರಿರುವ ಸೋನ್ಸೋ ಸ್ವತ್ತು ಈಗಾಗಲೇ ವಿಸಿ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಅಳತೆ 3540 ಮತ್ತು ವಿಸಿ ರಾಜ್ ಬಿನ್ ಲೇಟ್ ಚಾಮೇಗೌಡರವರಿಗೆ ಸೋನ್ಸೋ ಅಳತೆ 25x37 ಅಡಿಗಳಿಗೂ ಹಕ್ಕು ವರ್ಗಾವಣೆವಾಗಿರುವುದು ಸರಿ ಅಷ್ಟೇ. ಆದ್ದರಿಂದ ಸರ್ವಿಸ್ ಮತ್ತು ನಿಮ್ಮ ಹೆಸರಿಗೆ ಹಕ್ಕು ವರ್ಗಾವಣೆ ಮಾಡಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಎಂದು ಅಂಶವನ್ನು ತಿಳಿಸಪಡಿಸಿ ತಿಳಿಯುವುದು ಹಾಗೂ ನಿಮ್ಮ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳ ಪಕ್ಷದಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಚಟ್ಟಪಡಿಸಿಕೊಳ್ಳಿ ಅಂತ ಹೇಳುತ್ತೆ.
What is your right?
There is a description. We have inherited the property, and as the document the dimensions, and the dimension is considered in other property. So this should be a rectification.
How are you related to this VC Indira?
My lord, it is in para 3, my lord. VC Kutsami Gowda passed away on 23/11/2001, and thereafter, my lord, VC Kutsami Gowda and his siblings, VC Krishnappa, VC Rajanna, VC Ramu, Mari Gowda, VC Ramesh, and VC Indramma are legal heirs of late D. Chamegowda. And his wife Muddamma, further Chamegowda passed away in the year 1984. Subsequently, the immovable properties, including the property described in the schedule, herein under were transferred in the name of Muddamma. The Muddamma executed the registered will dated 18/12/1993 before the sub-registrar. And further, residential house property with the municipal number 827/760, measuring approximately 31 feet, west 35 feet, was bequeathed under the will to both VC Kutsami Gowda and Krishnappa. Later, Mutma executed residential house property, measuring 15.5 feet east to west and 17 feet.
Correct, but whatever the endorsement is correct. And this endorsement is issued in 2015, you're challenging it in 2021.
Yes, sir.
No.
My lords, I may be permitted to withdraw my petition and seek a remedy before the authorities.
So the Resident Counsel for the petitioner, after arguing the petition for some time, seeks the leave of the court to withdraw the petition and pursue the remedy before the concerned authorities. The submission is placed on record and the petition is dismissed as withdrawn. It is open for the petitioner to pursue the remedy before the authorities concerned. In accordance
Yes.
Various they may not so the property to Maranji was private.
But look at the relief that you saw. Please look at the relief.
I was also willing to inquire into the CAD with respect to a part that has been linked to the phone number.
Park.
Yes, sir. Area has been executed with respect to the property is linked to the phone number 2 for formation of parking. This deed is also annexed.
Who has executed the sale deed in favor of response 4?
Not the previous owner who did not have any title to the property. This property was earmarked as part. So I like take a lordship to annex.
AG is directed to accept notice for respondent number 1. They have MCC here. Is this? It's not Muda. It is Mr. TB Vivekananda is directed to accept notice for respondent number 2. Srimati Geeta Devi Papana is directed to accept notice for respondent number 3. Issue emergent notice to respondent number 4. Yes. Perfect. It is directed to accept notice to respondent number 1. Issue emergent notice to respondent number 2. Mr. T. Abdullah is directed to accept notice for respondent number 2. When was the when were you required to produce documents? 14/6/2021. As a last chance, 1 week time is granted to comply. The order date is 14/6/2021. Sir, you've taken 1.5 years time. 1 ವರ್ಷ ಆಗೋಗಿದೆ. Still you are not able to comply and you want 1 more. 2 weeks time is granted as last chance to comply. The order dated 14/6/2021. This on 8th June. It is made clear that that will be 8th June. Yeah. Name of Ellar of deceased all faithful state. 1 week time is granted to comply the office objections raised on IA 1 to 3 of 2021. To IA 1 of 19 for amendment.
Is it still number 6, my lord?
Yes.
I request for a week's accommodation, my lord. We'll look into it in the office and comply with the office objection, my lord.
To file objections to the amended petition. I could. Office objections raised on IA 1 of 2019 is overruled. Next paragraph. Petitioner has sought for amendment of the petition by adding paragraph number 15A and 15A to 15C and 15D, and also has sought for additional prayers. 15D, para 11A, para 11B. It has also sought for additional prayers. So since the petition is filed in the year 2014, it is appropriate that the amendment application is allowed so as to avoid multiplicity of proceedings. Since IA 1 of 19 is allowed, the counsel for the petitioner is directed to file an amended petition within a period of 1 week from today, failing which the petitioner shall not be entitled to the benefit of this order. It is open for the respondents to file statement of objections to the amended petition. The counsel for the petitioner is directed to furnish copies of the amended petition to the listener counsel for the respondents.
Much obliged.
The office objections raised on IA 3 of 2016 for recalling the order dated 2016. Overruled. The order the reason to the cause shown for the default appearing before this court on 16/2015 is accepted. Consequently, IA 3 of 2016 is allowed. The petition is allowed, and the order dated 16/2016 is recalled. The petition is restored to file. ಯಾವ ಸ್ಟೇಜ್ ಡಿಸ್ಮಿಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ ಸ್ಟೇಜ್ ರಿಸ್ಟೋರ್ ಟು ಫೈಲ್ ಸ್ಟಾಪ್. The learned counsel for the petition has filed a memo to withdraw the petition in view of the aforesaid, petition is dismissed as withdrawn. Notice correct idea. What is it, Henry? Insufficient address and 1 week time is granted to take steps in respect of unsolved respondent number 2.
My lord, in this case, by mistake, it was reported that the petitioner is dead.
Yes.
But the petitioner is not dead. There were 2 writ petitions in our office. 2 petitioners are same. They're going right. Different.
Petitioner is alive. He is alive.
Yes, that's all. I filed a memo of clarification.
Number 9. The learned counsel for the petitioner submits that inadvertently it was reported that the petitioner is dead while he is alive. Therefore, the submission is placed on record and the placed on record. Consequently, the order dated 14/7/2021 and 14/1/2022 need not be given effect. Yes, this is WP were order dated to be again. Mr. Shivrama, there is no representation for the petitioner. It is seen from the order sheet dated 27/10/2021. that 2 weeks time was granted to do the needful, failing which it was ordered the petition would stand dismissed. Since there is no representation for the petitioner, the petition is dismissed. 2 weeks is granted. Okay. But this is an auto passing election petition. Is it term?
For the respondent number 1.
But if there's a issue of corrupt practice, correct, but if there's an issue of corrupt practice, that has to be discussed.
The issue is one of caste certificate.
Oh.
And the term of the Jilla Gram Panchayat is also completed.
Correct, but if you have indulged in corrupt practice, that has to be decided.
No, we were the successful parties in the election.
Correct. If this court were to hold that you had indulged in corrupt practice.
No, the petitioner's claim is that no, we had challenged
the
the
petition is allowed. What happens?
No, the petitioner
is allowed. What happens?
No, the petitioner claimed that he was from the ST community.
So what about this respondent number 2? Who is respondent number 2? N. Krishnamurthy, returning officer. Note, you can AG is directed to accept notice for respondent number 2. This is the petition for fine hearing as per seniority.
Serial number 12, my lords. I am for the petition.
Yes, ma'am.
I am for the petitioner in this case, my lords.
Yes, I heard it.
My lords, actually, the steps has to be taken with respect to respondent number 5, my lords. I pray for some time in this case.
This memo for refusal of hand summons in respect of R5 filed by advocate for petition. What is the writ petition about? Madam, what is the writ petition about?
My lords, my senior is not keeping well, my lords, so I had to represent through this one, my lords. I am unaware of the
file with you.
I apologize for the same. I apologize for the same, my lords, but the file is not with me, my lords. So hence I had to come and break time in this case.
BWSSP, PESCOM and BWSSP. Mr. Venkat Reddy. PESCOM area. Mr. Devraj. Mr. Devraj is that. Devraj? R. Devraj? MS. Mr. Devraj is directed to accept notice for the respondent number 6. Mr. Maunesh Kumar is directed to notice for respondent number 7. To the R5, Men Lokesh. We'll direct you to serve a copy of this petition to this respondent number 5. 2016 the avoid ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ notice. What is this petition about? What is the petition about?
About the UAS. Yes, thanks.
Report.
You notice the
petitioner has sought for writ in the nature of mandamus to direct the respondents 1 to 4 to consider the representations dated 14/10/2015, 15/10/2015, 1/4/2016, bracket annexure A to D, and direct the respondents 1 to 3 to immediately take action to remove the unauthorized and illegal construction by restoring the setback on all the sides of the property, and further direct the respondents 6 and 7 not to provide electricity and water connection to the property owned by the respondent number 5. Extra. The notice of this petition was served to the was issued to the respondent number 5, but the same was not served. The hand summons issued to the respondent number 5 was refused by the respondent number 5 as per the memo filed by the learned counsel for the petitioner. In that way of the matter, since the respondents 1 to 3 are under a statutory obligation to consider the representations filed by the petitioner, the respondents 1 to 3 are directed to forthwith inspect the property of the respondent number 5 and consider the representations dated 14/10/2015, 15/10/2015, 4/1/2016, and 1/4/2016 in accordance with law and pass appropriate orders. It is needless to mention that the respondent number 1 to 3 shall hear the petitioner as well as the respondent number 5 before taking any action as per law. The respondent shall comply with this order within a period of 3 months from the date of receipt of the executive copy of this order. Yes. So one ವಾರ ಇವತ್ತು ಕೊಡ್ರಿ, ಇವತ್ತು ಪ್ರೋಸೆಸ್ ಕೊಡಕ್ಕೇನ್ರಿ? ಪ್ರೋಸೆಸ್ ಕೊಡಿ one Passover. Please pay the process. ಅದಕ್ಕೊಂದು ವಾರ ಮತ್ತಿನ್ನೊಂದು ವಾರ ಪ್ರೋಸೆಸ್ ಕೊಡಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ಬಿಡಿ. ನೆನ್ನೆನೇ ಬಂದಿರುತ್ತೆ ಕೇಸು, ನೆನ್ನೆನೇ ಪ್ರಿಪೇರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ರೆ ಆಗೋದು. Passover.
Serial number 17, my lord. And for the petitioner, my lord, I kindly pray for a date time, my lord. I'll comply by tomorrow.
Please pay the process today.
My lordship, I'm not well. Colleagues are not there. I kindly request for a date time, my lord.
Please ask one of your colleagues to pay the process. For paying the process, madam, issue notice. Please ask one of your colleagues.
I'll comply by tomorrow, my lord.
Sorry, madam. Today it has to be done. Otherwise, it will be dismissed. Please pay the process. Yes. Passover. ಇದೆಲ್ಲ ಕಟ್ಟಿ ಪ್ರೋಸೆಸ್ ಕಟ್ಬಿಡಿಪ್ಪ. Passover. Furnishing of certified copy of annexure C is dispensed. Yes. Copy ಶುರು ಮಾಡಿ. ಯಾವಾಗ? ಯಾರಿಗೆ ಮಾಡಿದಿರಾ? BBMP ಗೆ ಮಾಡಿದ್ರಾ, ಅಡ್ವೊಕೇಟ್ ಮಾಡಿದ್ರಾ? Yes. Mangla Bechinmat.
May I make one submission in all these cases where BBMP is a respondent, my lord? Courts ಸಾಧಾರಣವಾಗಿ ಏನು ಮಾಡುತ್ತೆ urgency ಇರುತ್ತೆ ಅಂತಲ್ಲಿ take notice ಅಂತ ಮಾಡ್ತಾರೆ. ಎಷ್ಟೋ ಸತಿ ಏನಾಗುತ್ತೆ they would not serve the copies on us, so we will also not be sure. So let it be directed to be issued to the corporation. Let the
serve copy on the council, Mr.
ಪ್ರತಿ ಸತಿನೂ ಇದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ ಸರ್ ನಮ್ಗೆ.
Directed to serve. ಆಯ್ತು ಪ್ರಿಂಟ್ ಔಟ್ ಹಾಕಿ ಏನ್ ನೋಡ್ರಿ ಚೆಕ್ ಮಾಡ್ರಿ. ಪಿಟಿಷನ್ ನಂಬರ್ 3 ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಅಂತ ತೋರಿಸಿದಾರೆ. ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ನೋಡ್ರಿ ಮಿಸ್ಟರ್, ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ನೋಡಿ ಕಾಸ್ಟ್ ಇಟ್. What about the other respondents? Shilpantidia. R2. The register is directed to rectify the cost title found in the High Court website of the High Court of Karnataka, so far as the petition number 3 is concerned. So when the learned counsel for the petitioner submits that the respondent number 4 has expired, and that you take necessary steps to bring the legal representatives of the deceased respondent number 4. Notice agilo iವರು ಯಾರಿಗೂ. The learned counsel for the petitioner is directed to serve copy of the writ petition to the learned counsel for the respondents 1 and 2. Issue emergent notice to the respondent number 3, 5, 6 and 7. This after service of the are 6 and 7 are this after service of notice to the respondent 6 and 7. Jackery, why you not served? Passover. Serve ಮಾಡಿ first ನೀವು. Passover. ಇದೆಯಾ 2 ಸೆಟ್ ಬೇಕಂತ ಅವ್ರು. ಇವಾಗ ಕೊಡಿ ಅದ್ರಲ್ಲಿ ತಿರ್ಗಾ ಇನ್ನೊಂದು ಸತಿ ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾರೆ ತಿರ್ಗಾ ಇದು 2 ಸೆಟ್ ಅಂತ ಕೊಡಿ ಪಾಸ್ವರ್ಡ್. Yes. Yeah, awaiting service of notice. Over this respondents 3 to 6 and 8. 3 to ಆಯ್ತು ಯಾರು ಹೇಳಿ ಯಾರು ಅಪೇರ್ ಆಗ್ತದೆ ಹೇಳಿ. Ajit Ajappa is directed to accept notice for respondents 3 to 6. Who is this respondent number 8? AGA is directed to accept notice for respondent number 8. What is this IA 2 of 22 for setting aside on? Please comply with this from office objections are there. 1 week time is granted to comply the office objections raised on IA 2 of 2022. Discount, when do you want it? 9th June. Yes. Interim order granted is extended till the next. Who is respondent number 4? So who is respondent number 4 first? That stone foundation. What about R4?
ನಮಗೂ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Copy. Passover. Please. Passover, Mr. If you don't serve copies of the petition, don't. Please serve it today itself. Adike Passover. Mr. First serve a copy of the petition to the council for the respondent. ನಿಮ್ಗೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಡುವಾಗ ಏನೇನೆಲ್ಲ ಕೇಳ್ತೀರಾ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲ ಕೊಡ್ತೀವಿ. Why don't you comply with this basic requirement? Please sir, Passover. Copy serve ಮಾಡಿ. Mr. What's your name? Mr. G? Yes. That is a full name, is it? Mr. G. Sridhar has filed a memo of appearance for the respondent number 3. Office is directed to, the memo of appearance is accepted. Office is directed to show the name of Mr. G. Sridhar as the counsel for respondent number 3. Yes. Please furnish copies, Mr. Now. English artha idalla. You understood English. Please serve the copy. What is this? IA for return of documents. These are documents marked as exhibits. Huh? What are the documents? These are all marked as exhibits. Wonderful.
The matter was disposed of but not present court. Since the name of the advocate was correctly mentioned in the matter, the matter was signed by Mrs. Shiva Associates. But the name mentioned was U.O. to refer to review petition. The applications may be listed along with the review petition.
No, review petition, I don't know. The Learned Counsel for the respondent submits the order on IA 1 of 2022. This is an application filed by the Learned Counsel for the appellant seeking return of certain documents which are marked as exhibits before the trial court. The counsel for the respondent submits that the review petition is filed to review the order passed, review the judgment and decree passed in this appeal. And therefore, these documents may not be returned to the appellant. It is also contended that the name of the counsel representing the respondent was wrongly shown in the cause list, and therefore the respondents could not be represented in this appeal. So, in view of the above, IA 1 of 2022 is disposed of, is rejected. It is open for the appellant to seek the return of the documents after the disposal of the review petition that is filed by the respondents. Yes. So what is the interim order granted? Yeah. D. What is annexure D, madam?
The main document in this petition is that reasonable opportunity to not be given to the petitioner, and so documents are not been verified. As
Madam, now they've issued a notice to you. Produce whatever documents that have to be produced in response to this notice. We'll direct them to. Correct, madam. We'll direct the authority to consider this as a show cause notice. You produce whatever documents that have to be produced. Let the authority decide whether the construction that you undertaken is in accordance with law or not. Thank you, madam. Purple. The petitioner has sought for correcting the nature of certiorari to quash the notice dated 1/1/2016 issued by the respondent. Bracket annexed D. The petitioner claims that the petitioner claims that he is the owner of a site measuring 30 feet into 40 feet, while Kata number 3418 and assessment number 3389 situated at Ramakrishna Extension, Srinivaspura town, lying within the limits of the respondent. Stop. The petitioner claims that she applied for permission to construct a building on the aforesaid land, which was granted on 20th of November 1993. Thereafter, she raised a loan and commenced construction of a residential house in the year 94-95, and that the petitioner has been residing in the said house for the last 20 years. Full stop. The petitioner alleged that since the compound wall was damaged, she attempted to reconstruct a compound wall in the same place. So at that time, the respondent issued a notice dated 20th of October 2015, which allegedly was not received by the petitioner. Later, the respondent is stated to have issued a notice dated 1/1/2016, directing the petitioner to remove the compound wall within 3 days. It is against this notice that the petitioner is before this court. The learned counsel for the respondent submitted that the learned counsel for the respondent has filed its statement of objections contending that the petitioner was issued with 3 show cause notices calling upon the petitioner to produce documents in support of the construction put up, and that the petitioner failed to respond to these notices, and therefore the respondent was constrained to issue the final notice calling upon the petitioner to remove the construction. Extra. This is, however, countered by the learned counsel for the petitioner, who contends that the petitioner has not received any notice. So, in view of the aforesaid submission, the notice dated 1/1/2016 issued by the respondent to the petitioner shall be construed as a show cause notice. The petitioner is directed to furnish her objections to this said notice and also produce documents in support of her claim to the property in question. To stop. The petitioner shall submit her objections within a period of 2 weeks from today, for 1 month from today. To stop. The respondent may, after hearing the petitioner, consider and dispose of the objections in a period of 1 month thereafter. It is needless to mention that the respondent shall hear the petitioner before passing any order. The petition stands disposed of on the above terms. Yes. Yes. Written again. No such address into them. Instead of the Therefore, they did not accept the notice. Now, better application are filed. Yeah, I have mentioned the others there. So I would request the court kindly issue notice on that item so that 29(3). The last for other bench. What had directed respond number 3 is dead. That is dead. All application very bad for the movement. Okay, they have no better application on that. So, but R3 is dead, is it? The Substituted Service Act on it. Right, Mr. If respondent number 3 is dead, why do you file IA1 for substitute service? So, substitute service for the LR part of the LR. So, respondent number 3 in the respondent number LR. Then you take out fresh steps to respondent number to LRs of the IA1 of 22 is filed for substituted service of notice to the LRs of respondent number 3. You seen that the LRs ಮುಂಚೆ ಹೋಗೇ ಇಲ್ವಾ? Grandfather's name is because they did not accept the notice. Your father's name was missing. He almost filed a fresh application. IA1 of 22 is filed for substitute service of notice to the legal representatives. So this is respondent number 3. The Learned Counsel for the petitioner submits that the legal representatives of the respondent number 3 were wrongly described, and that they are now correctly described in the application filed, and hence notice to the said respondents may be ordered. In view of the aforesaid submission, IA1 of 2022 does not require any consideration. Issue notice on IA2 of 2022 to the legal representatives of deceased R3.
I appear for the fourth respondent in this case, Your Lordship.
Yes.
I appear for petitioner in this case, my lordship.
What is that you sought for, madam? What is the stay granted?
Actually, there was a tea shop
So what is stay, madam?
in the footpath. Stay is granted with regard to annexure A.
Yeah. Yes, madam. This was listed day before yesterday.
Yes, Your Lordship. We could not contact the parties, Your Lordship. Today we are sending
All
letter
right.
to them. Over phone, they are not unable to contact Your Lordship. Hence,
madam,
I
you
pray
said
for
on
a week.
last date. Oh, I'm sorry. You said on the last date that you will get instructions whether they obtain the license or not.
Yes, Your Lordship. For that only we contacted them. Today morning only we contacted them, but we could not contact them.
Yes, madam.
And 1 week time we will send them the
Good. No time, madam. Either you get information today, I'll pass it over, or you will decide the case now.
we are unable to phone, Your Lordship. That's why we are sending letter today.
Madam, this petition has been pending for the last 3 years. And you
Yes, Your
took time on
Lordship.
the last date saying
I
that you will
agree,
get
but
information. Passover, please get
yes,
information.
Your Lordship. But
Passover. IA1 of 20. What is the stay grant? 28(3). What has happened to this funds? It's transferred.
Only filed an application on this contract. Others do not deposit the now the license
Mr. N. Kumar. Password. First point is 1 of 22. Notice issue ಆಗಿದೆಯಾ? Notice issue ಆಗಿದೆಯಾ? Notice on IA 1 of 22. This is our next. Mr. Shivkumar. ಹೇಳಿ ಏನು ಅಂತ ಹೇಳಿ. ಕೇಸಲ್ಲಿ ಏನಿದೆ? Don't close your eyes. When muchkodi. When muchkodi. ಧೈರ್ಯವಾಗಿ ಮಾಡಿ. ಹೆದರ್ಕೋಬೇಡಿ. Please argue. Again, what is the case about? You have purchased some property in a public auction. The property was sold in a public auction. Let him. Why did you deposit this 5 lakhs? For what? Now you please come to Annexure B first. Case you say that a property or the shop premises belonging to the respondent was auctioned, and the condition was that he has to deposit 5 lakhs. ಅಂತ ಶುರು ಮಾಡ್ಬೇಕು ನೀವು ಕಥೆ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಹಂಗಿರ್ತಾನೆ. That is how you narrate a story. ನೀವು Annexure D, E, F ಅಂತ ಹೋಗ್ಬಿಟ್ರೆ take your time. It should be like a story flow. ನೀರ್ ಅರ್ಧಂಗಿರ್ಬೇಕು. ಟಕ 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 ಅಂತ ಹೋದ್ರೆ ಎಲ್ಲಿ ಹೋಗುತ್ತೆ ಎಲ್ಲಿ ಬರ್ತೋ ಗೊತ್ತಾಗಲ್ಲ. ಹೇಳಿ ನಿಧಾನಕ್ಕೆ ಹೇಳಿ. Bid ಎಷ್ಟು? What is the total bid? What? You'll get back your 5 lakhs. Madi. You already taken back. Auction, what is the period of auction? Term is to for how many years? 1 year. ಯಾವಾಗಿಂದ ಶುರು ಆಗುತ್ತೆ? What is the term of the auction, Mr.? And when does it start? ಮತ್ತೆ ಫುಲ್ ಕೋವಿಡ್ ಬಂತಲ್ಲ, ಕೋವಿಡ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಇಲ್ಲ. ಕಲೆಕ್ಷನ್ ಮಾಡಿದ್ದೀರಾ? ಕಲೆಕ್ಷನ್ ಮಾಡಿದ್ದೀರಾ? ಕೊಟ್ಟಿದಾರಲ್ಲ, ವಾಪಸ್ ತಗೊಂಡಿದ್ರಲ್ಲ 5 ಲಕ್ಷ. $5 lakh, Mr. Have you received 5 lakhs or not? Have you received 5 lakhs or not? File an affidavit. On the affidavit ಹಾಕಿ 5 lakhs ಬಂದಿಲ್ಲ, ಅದು ವಾಪಸ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ affidavit ಹಾಕಿ. Next week it's ಬೇಡ. Have you received the amount or not? ನಿಮಗೆ ನಿಮ್ಮ 5 ಲಕ್ಷನ ವಾಪಸ್ ಬಂದಿದ್ಯಾ ಇಲ್ವಾ? No, I don't know. ಯಾವ ತಗೊಂಡಿದ್ದೀವಿ? File an affidavit. If he has taken, he will go behind bars for giving a false statement before the court. ಕೂಗಿ ಎಷ್ಟು ಕೂಗ್ತೋ ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಮಾಡಿ ಯಾರು ಬೇಡ, ನೀವು ಫೇಸ್ ಮಾಡಿ, ಆಪ್ಷನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ. ಹೆಂಗಾಗುತ್ತೆ ಹೆಂಗಾಗತ್ತಪ್ಪ? ಇವತ್ತಿನ ಸೈಜ್ ಪ್ಯಾಂಟ್ ಹೊಲಿಸ್ತೀರ ನೀವು, ಸ್ವಲ್ಪ ನಾಳೆ ದಪ್ಪ ಆದ್ಮೇಲೆ ಅದೇ ಪ್ಯಾಂಟ್ ಹಾಕೊಳ್ತೀರ. ಆಯ್ತು, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನಾವು ಎಂಟೈರ್ ಆಪ್ಷನ್ ಇಸ್ ಕ್ಯಾನ್ಸಲ್ಡ್. ನಿಮ್ಗೂ ಇಲ್ಲ, ಅವ್ರಿಗೂ ಇಲ್ಲ. ಫ್ರೆಶ್ You participate in the auction. When is the next auction? India. ಆಯ್ತು, ಇನ್ನೊಂದು 3 ತಿಂಗಳಲ್ಲಿ ಆಕ್ಷನ್ ಮಾಡ್ತಾರ ಅವರು. ಬರ್ಕೊಳ್ಳಿ. Mister, you should cultivate a habit of starting the case with the facts properly. ಬೆಳಿಗ್ಗೆ ಎದ್ದು ಬ್ರಷ್ ಮಾಡಿ ಸ್ನಾನ ಮಾಡಿ ಆಫೀಸ್ಗೆ ಬರ್ತೀರಾ, ಆಫೀಸ್ ಬಂದು ಸ್ನಾನ ಮಾಡೋದಿಲ್ಲ ಅಲ್ವಾ? ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಸೀಕ್ವೆನ್ಸ್ ಆಗಿ ಹೇಳ್ಬೇಕು. ಪ್ಲೀಸ್ ಮೇಂಟೈನ್ ದಟ್ ಸೀಕ್ವೆನ್ಸ್. ಮನೆ ಕೋರ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಬರಕ್ ಮುಂಚೆ ಒಂದ್ಸತಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ. ಏನಾದ್ಮೇಲೆ ಏನ್ ಹೇಳ್ಬೇಕು ಪಿಟಿಷನ್ ಒಂದ್ಸತಿ ನೋಡಿ, ಅದು ಸೀಕ್ವೆನ್ಸ್ ಮೇಂಟೈನ್ ಮಾಡಿ. ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ಗೆ ಅಭ್ಯಾಸ ಆಗುತ್ತೆ ಕೋರ್ಟಲ್ಲಿ. 2ನೇ ಸತಿ ಆಗ್ತಿರೋದು. 2ನೇ ಸತಿ ಕಣ್ಮುಚ್ಚಿದ್ರೆ ನಾನು ಕೋರ್ಟಲ್ಲಿ. ಹೋದ್ ಸತಿ ನಾವು ಇದೇ ಹೇಳಿದ್ದೆ ಅಲ್ವಾ RS ಅಲ್ಲಿ. And never close your eyes when you are arguing. ಹೆದರ್ಕೋಬೇಡಿ. ಬರ್ಕೊಳ್ಳಿ. The petitioner has sought for a writ in the nature of certiorari a right to quash the resolution of the respondents. ಯಾವುದು? Respondent number 2. Public auction conducted on 5/4/2021 and re-auctioning the collection of taxes and duty in respect of fair FAIR / Candy within the limits of the respondent number 2. So the petitioner claims that the respondent number 2 had invited bids for collection of tax for conducting fair, / Shandy, and that the petitioner was the highest bidder. To stop. The petitioner had deposited a sum of 5 lakhs and was anticipating the award of the tender to collect tax. So when things stood thus, the respondent number 2 held a meeting on 9/4/2021, where it was decided to cancel the public auction on 5/4/2021. And it was decided to conduct a fresh auction on 29/4/2021. To stop. The petitioner, being agreed with the aforesaid, has filed this petition on various grounds. The petitioner contends that petitioner contends that since his bid was accepted, since he was the highest bidder, the respondents could not have disturbed the bid and must have accepted the same. So, per contra, the learned counsel for the respondents 2 to 4 submitted that the respondents reserved the right to cancel the auction in entirety without assigning any reasons. Full stop. He also submitted that the petitioner has collected back the initial deposit of a sum of 5 lakhs. Therefore, the petitioner has no right to seek for any relief before this court in this writ petition. Full stop. The learned counsel for the petitioner was not able to dispute the fact that he has received back 5 lakhs after the auction dated 5/4/2021 was cancelled. Full stop. In that way of the matter, the petitioner is not entitled to challenge the auction that was cancelled on 9/5/2021. Full stop. It is, however, open for the petitioner to participate in the auction that may be conducted by the respondents. Full stop. That way of the matter, the petition is disposed of, and it is disposed of, and the respondents 2 to 4 are directed to conduct a fresh auction within a period of 1 month from today. Full stop. It is needless to mention that the petitioner shall be permitted to participate in the auction. Yes, please. Yeah, who has filed this application?
I appear for the proposed respondent, Your Lordships.
Who are you? Who are you?
I am the resident counsel. Mr. Bayareddy is not keeping well, my Lordship. Your Lordship may have it on next week.
Can you have a, if you have surrendered the roads and other areas to the government or the planning authority, so they can't be a gated community within BBMP limits. Full stop. It will be 30 feet, 300 feet. The question is, if you relinquish the road area to the planning authority, then you cannot lay a compound, you cannot enclose it. Everybody has a right to enter in free action. How can you? You can't have community full stop. That is a law declared by this court also. When will you argue? I think even without this respondent, you can still dispose of the case. Even without this respondent, the case can be decided. Date of your choice. Date. System second at the request of the council. Granted release, it can be to the next day. Yes. Pardon? Yes, ma'am. Notice ಕೊಟ್ಟಿಲ್ಲ ಸರ್ವೆ ಮಾಡಕ್ಕೆ ಮುಂಚೆ. You are not notified. Barcode. Pardon? Correct. What has happened there? No status quo, Mr. Take out notice first. DG has drafted accept notice for respondent number 1. Mr. Sarita Kulkarni is directed to accept notice for respondent number 2. Respondent number 2 and 3. Also for the petition is directed to please copy of the resolution to the government notice for the respondent. The Devi Prasad Shetty. The second opponent not undertaking any construction work in the process. He submitted the accepted In view of the transaction where it was on account of all petitioner is alleged that despite the name of the law transaction under required. There is no denying that it was responded to the but otherwise the necessary gets and it can be presumed that the necessary action on the part of the it is one sort of decision of other last time, we have the yes. All the dispute and read. What is the dispute? What is the dispute? Are these people claiming to be the same person? At the encroachment is a civil court going into ಹೇಳಿದ್ದಾರೆ. But ಇವರು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡೋದ್ರಲ್ಲಿ ಖಾತೆ ಆಗ್ಬೇಕಲ್ಲ. ಖಾತೆ ಮಾಡ್ಕೊಡಿ ಅವ್ರಿಗೆ. ಖಾತೆ ಮಾಡ್ಕೊಡಿ. ಅವರು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ. ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇಂದ ರಿಕವರ್ ಮಾಡೋದಕ್ಕೆ ಅಥವಾ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ. Why are you bothered? The petitioner, correct? The earlier owners had the Kata in their name. What is the difficulty in transferring the Kata? Please bring the Kata to the court. Kata in the name of the petitioner. Otherwise, you ask this ARO to be present before the court. No objection, Mr. Bring the Kata. Kata ಮಾಡ್ಕೊಂಡು ತಗೊಂಬನ್ನಿ ಕೋರ್ಟ್ಗೆ. Sir, there's a sale deed in and how many ಇದು ಮೂರನೇ ರಿಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಖಾತೆಗೋಸ್ಕರ. ಅಂದ್ರೆ ವಾಟ್ ಯು ಮೀನ್? ಇಸ್ ಜಸ್ಟ್ ನಾಟಿಂಗ್ ಯುವರ್ ಹೆಡ್ ಏನು? Some tax has to be paid. Next B. The petitioner is before this court seeking for a direction to the respondents to effect the Kata, to enter her name, register extract Kata in respect of the property bearing municipal number 3, old number 112, CID number CID-3-3 situated second main road. It is unfortunate that the respondents have forced the petitioner to approach this court on 2 occasions earlier, seeking for the very same reliefs, and yet the respondents have now rejected the claim of the petitioner on the ground that the adjoining owner on the ground that the adjoining owner is, on the ground that the adjoining owner has encroached into the petition. To stop, if the petitioner has purchased the property, if the petitioner has lawfully purchased the property, the respondents are bound to enter the name of the petitioner in the assessment register, which is only to assist the respondents in identifying the person responsible for payment of property tax. Since the petitioner is forced to approach this court time and again, instead of directing the petitioner to approach the respondents, it is appropriate that the respondent is directed. The respondent number 2 is directed to secure the Kata in the name of the petitioner and furnish the same before this court. This is, however, full stop. It is, however, made clear that the petitioner shall be liable to pay the Kata transfer charges and other charges as applicable. This petition on Kata court to come. Should bring the Kata to the court. Yavat 1 month already. Kata application kottidiyalla in 1 month ಏನು? It's the petition for complaint of the order on 13th June 2022. It made clear that if the respondent number 2 does not come with the Kata in the name of the petitioner, the respondent number 2 shall remain present in the court. Election petition ಆಗ್ಬೇಕಲ್ಲ. You have to file an election petition. There is a law declared. Election commission, election petition. Election petition. Page number?
ಮನುಷ್ಯ ಚೇಂಜ್ ಆಗ್ತದೆ.
Connection? What is the representation given by you? You have to file an election petition. Complain ಮಾಡಿ election petition ಆಗ್ತದೆ. ಕೊಡ್ರಿ section 19.
ಉರ್ದು
Yes, you have to file an election petition. Once the election is over, they become functus officio. They cannot undo an election. The election agodmele, you can make a complaint. They are bound to decide it only if the law requires them to decide. Where is the requirement that they should decide? Sir, if there is any law which requires the respondent to consider a representation, we will issue a direction. Where is the law? ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ ಮಾತ್ರಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ಇಲ್ವಲ್ಲ. Just because you lodge a complaint Is it required that your complaint should be determined by the election commission? Election authority.
It is not,
You can take it that it is rejected. Still, they are not required to decide your representation or your complaint. The only way provided is under section 15. Other prakara hakobodu. After the election is over, what should happen? Please tell us. Election ಆಗೋದ್ಮೇಲೆ ಏನ್ ಮಾಡಬೇಕು? If there's any issue, ಅದು ಡಿಸೈಡ್ ಮಾಡೋದು ಯಾರು? ಎಲ್ಲಿದೆ ತೋರ್ಸು ಎಲ್ಲಿದೆ? Which is the provision? Election authority has to decide ಅಂತ ಎಲ್ಲಿದೆ? Before the election, what you say? Nomination ಮಾಡುವಾಗ what you say is right. At the time of nomination, that is over. That is over, mister. That is already over. The election is completed, then what is the remedy now? If you want to challenge the election? Really? ಅಷ್ಟೇ ಅಲ್ಲ? Page number 58. Courts, State Election Commission can consider is bound to consider your representation. The courts. Don't waste your time barking the wrong tree. ಹೌದು, GSC ಹಂಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, DC ಹಂಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲೆಕ್ಷನ್ ಯಾರು ಮಾಡಿದ್ರೆ ಇವ್ರು ಮಾಡ್ಬೇಕು ಅಂತನಾ? ಇವ್ರು ಮಾಡ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ಸರ್. ನಾವು ಊರು ತುಂಬಾ ಹೋದೆ, ಯಾರು ಕೇಳಿಲ್ಲ, ಅದಕ್ಕೆ ಇವ್ರು ಕೇಳಿದ್ರೆ where is the requirement that election commission, state election commission has to consider your complaint? Please show it. ಎಲ್ಲಿದೆ ತೋರಿಸಿ. Please look at the section 15, 19, madam, 19, 1A. Just more. 38. 38. Advertisement tax. The council for respond number 1 and 2. When will you do it? 39. Shankar Narayan Bhatt. 38.1 interim order granted and get till the list. What is this 38.1, madam? That is also related to advertisement tax. So we have inspector of police and AG is directed to accept notice for respondent number 8. 38.1 again. 10th. Yes. Make an application for 40. Clifton Rosario.
I'm appearing.
I appear for third respondent, third and fourth.
Yes, sir.
My lord, I'm appearing for respondent number 2, Clifton D. Rosario, on the matter. May I request a Passover in this matter, my lord? Clifton is on his feet in another court.
Let the counsel for petitioner begin, madam.
Please.
Please follow his arguments. Yes. Yes.
Each side measuring 40 by 38. So many related respondents go 5 and 6. They try to be interested in the land or the part of this side.
They claim to be. They claim to be.
To be or the according to be grantee of acres of land. 7 number 7. Respondent. They could be in unauthorized cultivation of objectional land. 7 number 57 of Kota village. They filed an appeal to the city officer, Allotment.
Yes.
Which is telling that they are and the owners reservation and the site planted to release persons is illegal and exciting. The appeal, notices were issued. The petitioners also received notice.
Yes.
Intimately the date of hearing.
Yes.
The date of hearing was fixed as notice received.
What happened to the civil suits?
Suits are decreed.
Decreed.
Pending when I went to see. Those suits have been decreed.
Then how does this petition survive for consideration?
Oh, the allotment has been cancelled.
Cancelled.
By the executive officer. The appeal. He passes an order. It's not that I was trying to give you a
Annexure?
Hearing of the appeal, yes, for 2011 annexure Jiva.
Yes.
So we were asked to appear before him on the said date.
Yes.
When we appeared there, the case was not issued. Then we were told that it would be intimated to us. We were shocked when we learned that the order has been passed on 22/11/2011. What is the order has been passed on the basis of the reports dated to have been submitted by the citizen and the order.
Where is the order sheet?
Annexure H is the order.
Order sheet.
Order sheet.
Annexure J.
Page 100. You see,
that's
the very first date of hearing. You see that the order sheet. Very first date of hearing was on 49/2011.
Only there, sir. 14/9. Where do I find it?
See, the record one.
Correct. 100 starts from 5th of July.
5th of July
Appeal ಆಗಿತ್ತು. Correct. ಆಯ್ತು ಅದಾಯ್ತು. ಯಾವತ್ತು ವಾಟ್ ವಾಸ್ ದ ಫಸ್ಟ್ ಡೇಟ್? What was the first date after the notice?
As per the scheme here is 49.
Yes.
That's right. And one day, 13 ಸೈನ್ ಹಾಕಿದ್ದಾರೆ.
13/7 4/8 ಹೋಯ್ತು. 4/8/11 ಮುಂದೂಡಲಾಗಿದೆ. Then 14/9/2011. What is this? Where is the order passed by the respondent? Page? Who appears? Who appears for the panchayat?
I appear for Gram Panchayat. Our second respondent advocate or Passover. Contesting respondent Devraj, H.K. Devraj.
Yes, Raghupati.
ಅದು ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರು.
ಆಯ್ತು, ಓದ್ತೀವಿ. Gone through that. I've gone through that. ನೋಟಿಸ್ ಕೊಟ್ಟರು ನೀವೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ ಅದು ಇದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳು ಮತ್ತು ಅಧ್ಯಕ್ಷರು ಆವೃತ್ತಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಾರ್ಯದರ್ಶಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಹಾಜರಾಗಲು ವರದಿ ಆಯಿತು. ಅದರಿಂದ
2211 ರೀ.
2211 ಆರ್ಡರ್ ವರದಿ 100 It is that one we don't know. So how could it be subsequently ordered? On that worthy basis, my is the allotment and yes.
Yes, Mr. Mr. S. Raghupati.
ಅದೇ ಅವ್ರ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರು ಈಗ.
ಯಾರು?
ಅದೇ ಆ ಲೇಡಿ ಇವ್ರ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರು.
ಲೇಡಿ ಅಪೇರ್ ಆಗಿದ್ದು ಕ್ಲಿಫ್ಟನ್ ರೊಸಾರಿಯೋ.
ಹೌದೌದು, ಅವ್ರು ಒಟ್ಟಿಗೆ ಹೌದು.
Yes, madam.
My lord, may I request a Passover in this matter? Clifton is on his feet in another court.
Did you understand what is argued?
I'm actually not able to hear him, my lord. I've asked my colleague to come to court.
Michael, please speak into the mic for the benefit of lawyers and the VC. Madam, you please come to annexure H. You have a copy of the petition or not?
Please, my lord, the petition is with my senior. He's on his feet.
Passport.
I apologize, my lord.
Yes. Our neighbors. You are constructed according to plan. India. Yes, who appears for the respondent?
I appear for the respondent against the notice issued by the Panchayat Development Officer. He had filed an appeal. Appeal 269 ನಲ್ಲಿ against original order ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ ಹಾಕಬಹುದು. ಅದ್ರ ಮೇಲೆ ಬಂದಿದ್ದಾರೆ. ಈಗ ಅದು appeal dismiss ಆಗಿದೆ.
They sought for a mandamus to
ಅಲ್ಲ annexure A ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ.
Actually, a question ಮಾಡಿಲ್ಲ sir. We are at serial number 42.
I'm sorry. ನಾ 41 ತಿಳ್ಕೊಂಡೆ. ಸಾರಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಏನಾಗಿ. Sorry.
41 is adjourned.
I'm sorry.
Yes. So, A. Nagarajappa for R1. Yaar, who appears for the corporation? Tumkur City Corporation. Yaar. Star Subramania. But will he appear? Star Subramania is expected to accept notice for the petition as a respondent number 2. Since what about City Corporation? Respondent number 1 and 2. Sri A. Nagarajappa no longer represents the respondent number 1 and 2. Counsel for the petition is directed to furnish copies of the petition to Sri R. Subramania. Where is his property? Ian, what is the nature of construction that they have to do? ಅಲ್ಲ ಹಂಗಿದ್ರೆ ನಿಮ್ದು ಚೆಕ್ ಮಾಡ್ಸೋಣ ಹಂಗಿದ್ರೆ ನಿಮ್ದು ಪ್ಲಾನ್ ಪ್ರಕಾರ ಕಟ್ಟಿದ್ದೀರಾ? No, it can cut both ways. ನೀವು ಕಾನೂನುಬದ್ಧವಾಗಿದ್ರೆ you can expect others to be law abiding. What is this? Plan of whose plan? Objection objection file ಮಾಡಿ produce ಮಾಡಿ, you may not even pursue the petition. Whatever it is, but if he has obtained a plan, let him put up construction according to the plan. In the meanwhile, the learned counsel for the respondent number 3 is directed to file the statement of objections. Based on when do you want? Please don't say next week. Please pick a date. Date. 12th. First just it's on third Saturday. Sorry, third is Friday. 3rd June. Please show copies of the Mr. Bhimappa Talageri, Avanesh Sudardi, Bhimappa Talageri, Bhimappa Talageri. Is this lawyer still on the panel of BBMP? So, there is no representation for the petitioner. But it is seen that the petitioner has challenged an order passed by the Karnataka Appellate Tribunal, appeal number 630 of 2010, by which the confirmation order under section 321(3) of the KMC Act was set aside. But there is no representation for the petitioner. It is not known whether the Tenant Council represents the petitioners or not. Hence, is there any lawyer for BBMP? Office is directed to show the name of Mr. Ashwin S. Haradi as the learned counsel for the petitioner in the first list, along with Mr. Bhimappa Talageri. This is the petition on 6th June.
Respondent by me.
Is there a Mr. Prashant or
Yes, my lord.
Bhimappa Talageri, yaar advocate?
ಬಹುಶಃ ಇದ್ದಂಗಿಲ್ಲ ಅವರು ಪ್ಯಾನಲ್ ಇದ್ದಂಗಿಲ್ಲ. I have not heard of his name.
Yes, please. Page 31. Employee's obligation. Employer is also the in addition to any of the other obligation methods, the employer shall have the following of the employer shall deliver all cost possession and the remaining portion of the period of the appointment. Then so they need to hand over the fund. Cross the Article 14. The employer need to deliver project period in accordance with the Article 2. The contractor shall issue a termination. So the total work that was awarded in respect of package 1 is 42 crores 40 lakhs. I have also given a bank guarantee for the execution of the start and period next year ECC. So our bank guarantee was for 4 crores 24 lakhs. Because immediately once the BBMP had able to deliver this work front to me in the time bound manner, and the ones that were also given to me because there were encroachment, there were residential buildings, certain lands belonging to railways, where the permission of the railways were not. Finance was not able to commence the work and conclude the work.
What is there to say, show that you have terminated the contract?
I exercise that option of termination because I have written letters, approximately on page 59. Direction DC is page 9 of that letter. She stated 22/7/2006. But under the contract, the work was to be completed by 30th of September 2007.
Yes.
This letter is dated 22/7/2006. This is addressed to the commissioner. But the not may see Roman 1 2 last time Roman 1 and the area located between for this and
Jakkarayana Kere.
On either side of the residential building widening was being proposed along the right hand side of the range. And similarly, not over the two large land the land last of the land belonging to railways and permission of the railways has to be paid for widening. Similar work is given in respect of each of these areas which
Ultimately, what happened?
What happened is the conciliation meeting was conducted by the BBMP, but it was not announced to the and I could have not handed over the first one. Ultimately, there is another package which I have produced in similar documents. My notes were down to see that conciliation meeting, where one of the BBMP page 41 in production. Page 40, 140. 140, election 10. This is dated 6/2012.
Yes.
Addressed by us for the BBMP. Come to the last paragraph.
So this is for Vishwavati Valley. Are we concerned with the same thing in at page number 59 also?
Yes.
Did it relate to the same Vishwavati Valley?
Yes. Relates to the same one. Subject analysis.
Yes.
Page 140 is not come to the last paragraph. Under that was requested that the project made is the close and release the final bill payment and the liability submitted to BBMP. The contract is foreclosed without respect cost and release of all the.
Where is the question of this final bill? What is this final bill?
What happened is that we have executed the portion of the work. So in respect of the work that we have executed, we have submitted the bill.
The rest of the work could not be executed because there was no work front available. However, my lords, page 141. This is the conciliation proceedings held by the BBMP. Where not may turn to page 143, the last page, has been the members of the committee. Was all appointed by the BBMP.
Yes.
6 of them. Lords may come to paragraph 3 at page 141. Such of the agencies who have executed part of the work have attributed the non-completion of the scope of the work in their contract due to various impediments, like non-availability of the work due to encroachment, public protest, intervention, etc. Due to the difficulties faced by them, work has been stopped by various agencies in different stages in 2009. Then Lords may come to the, I will not cover the rest of the stage. Page 143. This is the final resolution clause. 9.1. ECCI Limited is the petitioner. Has undertaken the work of demodeling the private secondary They have agreed to postpone sending the contracts ordered to them with the request to release the payment due to the contract and the FSD amounts recovered by the balance of the work can be executed by any other agency without operating at their extent, and they will not put forth anything. Their better paying also to be signed by the authorized closed by sanction. Stating committee having analyzed the request of the agency, the payment due to them for the work executed earlier has to be released and return recoveries made as FSD. Committee opined that the balance work can not executed by the BBMP by any other agency and not at the state cost of all issues arise in the future stand settled the approval of the competent authority. This committee's decision was once communicated to the government page next time, page 144 by the BBMP. And the government's permission was requested to upload the contract. Where was they narrate the fact that admittedly BBMP has not handed over but other difficulties. 153 was the request for the position of the government. But thereafter the certain queries was made by the government. If 154 is another letter by the
Ultimately, the government approved it.
what happened is once the government by passing government order cancellation committee's resolution doesn't is considered. Automatically says this contract is foreclosed, but it shall be at the risk and cost of the page 162 is one of the operative portion of that order. Hence, BBMP is authorized to foreclose at risk and cost to the contractor. The following relevant packages. So, the number B there is package 1 and 5 is fine.
Selection proceedings as per government order by direction are is concerned. There is no amount regarding to that, but the proceedings should regarding to the committee as well as
Because the BBMP itself is accepting that they are at fault. They couldn't hand over the work front to the petitioner. How will the petitioner carry out the work? In fact, in PWD contract, not handing over possession of the site is a ground for extension of the contract period. And there's also that would be a case for escalation of the price also. If that is so, how do you say that government can fix the responsibility on the contractor for your mistakes or the mistake of the BBM? One 161.
estimates and the rate of the balance quantity. Quantity is including total work six and add items assuming the price estimation. BBMP players and they as per current rate.
They don't want to work. They don't want to work. You might ask them to work as per the PWD schedule. They don't want to work. They'll say that we had quoted a particular amount pursuant to a bids which were invited. Now you can't ask them to work as per the PWD schedule. They'll say will not work. It's not commercially not feasible for them. Yes. Somebody is Yaro encroach can we remove the encroachment? So you have to keep give the project site without any encumbrance, without any disturbance, so that he can work out or execute the tender, execute the work. Sorry. He has to be paid back his EMD, and BBMP is willing to accept that. Why is the government singing a different tune?
May I submit?
Yes, please.
My lord, this is a works contract where there is a provision for arbitration. They have not invoked the arbitration. Now the challenge is only page number 41. Son.
Where is the clause for arbitration?
Page number 45. Contract clause 17.1. I see. Say where expressly stated to the contrary in the agreement, any dispute, differences, or controversy, or whatever nature between the parties, howsoever arising under out of the relation to this agreement, shall be in the first instance be attempted to be resolved amicably between the parties. Any dispute which is not amicably resolved by the parties shall be finally settled by the Commissioner BBMP, whose decision shall be final and binding on both the parties. Pending submission, so and so, so and so. Now, this has been interpreted by a single judge of this honorable court to say that the commissioner cannot be a disputing commissioner, cannot be arbitrator, and that's equivalent to an arbitration clause, and it's a reported judgment. So my submission is this because I understand the petitioner's anxiety. If he accepts this, then the limitation would probably come his way. May I submit, my lord? Let the annexure be quashed.
Government and its agencies, you want to stand on technicalities. When the BBMP says, when the BBMP says that the project site could not be handed over to the petitioner, and you want to hang on to this 4 crores, what is the amount? EMD is to.
The EMD, guarantees must have expired. My clear so far as return of those bank guarantees cannot survive from this.
Yes. So what survive?
Only confined to this minus clause.
What is it? What has happened to the contract? It must have already been executed.
It is not complete. We have foreclosed it, and somebody else is doing the contract.
Somebody else is doing it. There's nothing for you.
He has to make a claim against.
Here's the risk and cost. The contract is already awarded to somebody else, and he is executing.
To recover any amount. Or if the regulation is dismissed.
When they raise a demand, you can come to the court. All right, when they raise a demand, see, there should be cost and risk. Now, if the person who has now taken up the work, if he has quoted a higher bid, he has quoted a higher amount, then that might become a cost for you or a risk for you. Now, let the BBMP come up with a demand. How will they overcome these letters? Then you challenge it. You challenge it then. We will reserve right for you to challenge it. We will reserve right for you to challenge it when there is a demand.
Exactly. BBMP can raise a demand.
Can raise.
So
So you cannot come to the court on an apprehended cause of action. It may do it, it may not do it.
I would submit that's only a consequential action of the BBMP. Once the government has already taken a decision that it shall be your estate law. Moreover, the BBMP will only have to quantify that amount.
Let them quantify and then challenge. You challenge it then.
Because BBMP is an instrument director of the state. But BBMP could not have taken a decision of foreclosure, and that's why they wrote to the government. Government was not seeing the employer.
They will have to send you back to arbitration. If you want to go, you can go.
Arbitration apply because it is within the parties. It depends between BBMP and me. They are not agreeing with the action of the BBMP. It's the government. Government is the third party as far as the contract is.
Correct, but the demand will be made not by the government, it will be made by the BBMP.
But it will be only consequential to this government order. Once the government has already taken a decision that.
If you want to consult, you consult. We'll reserve liberty to you to challenge in case if BBMP ever raises a demand.
BBMP ಮರ್ತೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ, ಇವ್ರು ನೆನ್ಪು ಮಾಡ್ಬೇಕಷ್ಟೇ ಈಗ.
ಯಾವಾಗ? Monday. The list on Monday. At the request of the Learned Council for the petition. Yes.
Well, 46, I am attending on behalf of Mr. B.V. Krishna.
Yes.
Annexure C may kindly be seen.
Annexure C.
I am a landlord. I am the owner of a premises. The tenant has built certain things. The annexure A is the notice issued by the municipality Mangalore, Municipal Corporation Mangalore, saying that we will take action against the unauthorized construction. They contradict in by annexure C, saying that this is a land tribunal matter, therefore you go to the land tribunal.
Land tribunal.
ಎರಡನೇ ಪಾರ ಶ್ರೀ ಸದಾನಂದ ಭಟ್ ಅಂದ್ರೆ ನನಗೆ
I don't understand what is this ಸದಾನಂದ ಭಟ್
ತಿಳಿಸಪಡಿದ ಉಲ್ಲೇಖ ಒಂದರ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಮಂಗಳೂರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯನ್ನು ಸಂಪರ್ಕಿಸಿ ಪ್ರಕರಣವನ್ನು ಇತ್ಯರ್ಥ ಮಾಡಿಕೊಳ್ಳಲು ತಿಳಿಸಲಾಗಿದೆ.
Whether the illegal construction can be decided by the Bangalore, the ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ. Please come to annexure A. Please come to annexure A. Please read annexure A. 321(1), 321(2) ನಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡೋದು. Please read. Please read annexure A. ಅದರ ಮೇಲೆ ಓದಿ. ಇದಕ್ಕೆ ಉತ್ತರ ಕೊಟ್ರಿ. ಅನ್ನೆಕ್ಸ್ ಬಿ ಪ್ರಕಾರ ಉತ್ತರ ಕೊಟ್ರಿ.
ನಾನು ಕೊಟ್ಟೆ, ಅವ್ರು BBMP ಗೆ ಮಂಗಳೂರಿಗೆ ನಾನು ಕೊಟ್ಟೆ, ಕಾರ್ಪೊರೇಷನ್ಗೆ. ಸಿ ಪ್ರಕಾರ ಅವರು ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರು.
High Court, some writ petition is filed by the Sadananda Bhatta that was allowed and remanded the matter to the land tribunal for fresh inquiry. Has no title over the land. Copy of the order passed on. Correct, madam. You are only concerned about the plan, whether he is putting up construction according to plan or not. Whether he has got title or not, the tribunal will decide. Whatever. Forget the tribunal. Is put. Right, madam. That's the title, guys. That is in respect of title to the property. Madam, whatever you want to do, you do it. But if you take a plan, construct according to plan. We are not concerned about title in this case. We are only concerned about the construction, whether it is according to plan or not. Simple. Is what has happened to the land tribunal?
ಇನ್ನು ಅದೇನೋ ಪೆಂಡಿಂಗ್ ಇದೆ ಸಮಯ. It is still pending there.
No, she says that it is already disposed of.
I am not aware whether it is disposed of recently. Anyway, that is not for the municipality to Mangalore Municipal Corporation to say. Let them take action as per their own annexure A.
Who appears for Mangalore Municipality?
Harish Bandari ಅವರು ಇದ್ದಾರೆ.
Mr. Harish Bandari. Mr. Harish Bandari. Let them take action. Let them take action according to plan. But not necessary, madam. We are not concerned about title, madam. We are not concerned about title. See, if you want, madam, if you want to put up construction, you should take a plan. Correct? Plan ತಗೊಂಡ್ರೆ plan ಪ್ರಕಾರ ಕಟ್ಟಿ ಅಷ್ಟೇ. I work with the petitioner. I sought for a writ in the nature of certiorari to quash the endorsement dated 4/3/2014, passed by the respondent number 1, refusing to entertain the complaint against illegal construction put up by the respondent number 2. Etc. The petitioner claims that the respondent number 2 is his neighbor. Neighbor,
the tenant.
The respondent number 2 is a tenant under the petitioner. And that he was attempting to put up construction illegally in the land bearing survey number 266/2, na? 266/2 of Kadri B village, Mangalore Taluk, which lay within the limits of the respondent number 1. He therefore submitted a complaint before the respondent number 1, and the respondent number 1 acted thereon and issued a provisional order under section 321(1) and 321(2) of the Karnataka Municipal Corporation Act 1976. Full stop. In the meanwhile, the application filed by the respondent number 2 before the land tribunal claiming occupancy rights in respect of the aforesaid land was pending consideration before the land tribunal. Avaga, it was pending consideration before the land tribunal. Full stop. The respondent number 1 therefore issued the impugned endorsement directing the petitioner to approach the land tribunal for necessary reliefs. Is this endorsement which is challenged by the petitioner in this petition? The learned counsel for the petitioner submits that the land tribunal has no jurisdiction to decide upon the legality of the construction undertaken by the respondent number 2, and therefore the respondent number 1 is bound in law to take such action as is provided, as is stipulated under section 321(1) and 321(3) of the Karnataka Municipal Corporation Act. Per contra, the learned counsel for respondent number 2 submits that the petitioner is the landlord while the respondent number 2 was the tenant in respect of the aforesaid land, and that proceedings were pending before the land tribunal. And perhaps it was due to that the respondent number 1 directed the petitioner to approach the land tribunal. The learned counsel further submits that the proceedings before the land tribunal has now been decided, and the respondent number 2 has filed WP number. Is now decided. The petitioner has filed WP number 20734 of 2021. Full stop. The learned counsel therefore submits that the petitioner is not entitled to challenge the construction undertaken by the respondent number 2. Next paragraph. If the land bearing survey number 266/2 of Kadri B village lies within the limits of the respondent number 1, then the respondent number 1 is bound to ensure that the construction put up within its limits is in accordance with the building bylaws as well as the zoning regulations. Full stop. If the respondent number 2 has undertaken construction in an area which lies within the limits of the respondent number 1, the respondent number 2 is bound in law to obtain necessary plan and license from the respondent number 1 and thereafter put up construction in accordance with plan and license. If that is not done, the respondent number 1 is bound in law to decide the validity of the construction and take appropriate action against the construction put up by the respondent number 2. The respondent number 1 cannot shirk its responsibility by claiming that the parties are litigating before the land tribunal. Full stop. The land tribunal has no jurisdiction to decide about the construction, about the validity of the construction put up by the respondent number 2. In that way of matter, this petition is allowed and the impugned endorsement issued by the respondent number 1 dated so and so is quashed. The respondent number 1 is directed to consider the objection, if any, filed by the respondent number 2 to the notice dated
5/2012.
3/2012.
Annexure A.
As per Annexure A, and take such action as is permitted, as is prescribed under law.
On time limits.
Construction put up by the respondent number 2. Full stop. It is needless to mention that if the respondent number 2 has not filed any objections to the notice at Annexure A, the respondent number 1 shall permit the respondent number 2 to file objections within a period of 1 month from today, and thereafter pass appropriate orders within a period of 3 months from the date of receipt of the objections filed by the petition by the respondent number 2.
Obliged.
48, I appear for the respondent number 22, my lord.
Yes.
There is no relief sought against me in the writ petition, and in addition to that,
Withdraw. What do you want? So the learned counsel for the petition has filed a memo to withdraw the writ petition. The memo is based on record and the petition is discussed. Not with K.C. Shantakumar. The K.C. Shantakumar. Shekhar Shetty.
I appear for petition on my lord.
Yes, sir.
Your lordship may be pleased to see the site number 10 found in layout block number 42 in Hasana district, that is, now it is Hasana Corporation area, was allotted to the petitioner herein as per the endorsement dated 5/5/1988. Annexure A, your lordship may be pleased to see. And they called upon her.
Who has formed this layout?
Huh?
Yaar form out of layout?
Municipality. Karnataka municipality, the Hassan municipality, and allotted it, and they asked me to pay 1,000 rupees within 3 days. I paid that amount, that receipt is there. Your lordship can be seen. Later, even they sent a letter to the government also. They allotted this to approve the same. Then ultimately they gave a position certificate to me. That is Annexure C. Then they gave sanction plan and a license to me construct in 1994 itself. Thereafter, I put up a construction, and the RCC building is there of 7 squares. It is undisputed in all the taxpayer receipt that entries are there. But the sale deed is not executed. I requested them to execute the sale deed. They did not execute it. Now, ultimately, I filed this petition before this honorable court for a direction by the mandamus to execute the sale deed and not to interfere with my position. After 6 years, they filed the objection. After filing 6 years, your lordship may can be please kindly see the objection statement of them.
Yes, sir.
In that also, they never dispute that they have received the sale consideration and the allotment. They say, no, the signature is not from the competent officer. But the person who has sworn into affidavit is not at all there in that office at that time. The person who has signed this document never said it is not my signature at all. Even signature to the government also he never said. And the ones they have received the money, they never dispute they have received the money.
How did they receive the money, sir?
By only bank challenge. Your lordship is, they passed the Annexure A itself. They said within 3 days you must pay the money, 1,000. Then at once I deposited in the bank their account. Challenge is also affixed in the Annexure A itself. Your lordship may kindly see.
Let us hear the respondent. Annexure?
She assumes that she is the commissioner, traditional court. She forges the signature. Her signature is paid. Annexure B document, which they rely upon. How you pay the annexure. Total, she is the petition. So, mandamus is sought. We deny the entire exercise. If we have got similar meeting, forgery. See, the commissioner will do commissioner letter, the municipal letter. That is what can take action against this.
The Putlakshmam and the Pauraikuru Idro ಏನೋ ಗೊತ್ತಿಲ್ಲ.
So that is the 4th letter. Liable for action. So you might deny the title. Only way is mandamus cannot be punishable.
What about Annexure C?
Annexure C. No signature was named. Not addressed to any person.
It's not addressed to the possession certificate.
Srimati. And signature ಮಾಡಿಲ್ಲ. Annexure C. In page 15.
That gay and through the 2. That is a
signature. Commissioner signature. Cyclostate copy. The last word of the government. So we deny. If at all she feels that she has right in the immovable property, she has to go in the manner known to law. We deny this. Payment of tax may not get any right of title of immovable. And annexure B. No details about
Where have you mentioned that annexure A and B are forged, fabricated?
Objections. Para 4. It is submitted the municipality has not issued the notice as contained in the petition of annexure A. But here to state that even the two address shown there in forged and past inserted the petition incorporating A as reflection. And name is purposely indicated reflection or not also as potentially. Signature shown is not the signature of the commissioner, and the said notice was never issued. Next, submitted annexure B communication is created now. Those and document indicates that.
No, who was the mayor? Paura Ayuktar Undre mayor. Commissioner. Who was the commissioner at that point in time? Find out. 94 year commissioner is of course. March to 1994. So they already constructed a house.
My lord, thank you. They shall be very fine. That person. Which relationship they feel that we have done anything.
How do you justify it, sir? Annexure B ನಲ್ಲಿ ಪೌರಾಯುಕ್ತರ ಹೆಸರು ಪುಟ್ಟಲಕ್ಷ್ಮಮ್ಮ ಅಂತ ನೀವೇ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ. Please come to annexure.
Our commissioner ಇದೆ. I seen I'll submit my annexure A signature ನೋಡಿ commissioner annexure B ನೋಡಿ. So ಅವ್ರದ್ದು signature ಇದೆ. How they are taken her signature we also can't explain it. My client says they are not signed it. What will be the case?
The annexure A is 5/1988.
88 sign ನೋಡಿ ಅದಕ್ಕೆ ಸಣ್ಣದು ಇದು ಮಾಡಿ ಅದೇ ಸೈನ್ BNB ಇದೆ.
Sir, 88 commissioner, how can he continue in 1994?
I don't know.
Annexure A is issued in the year 1988.
Correct. That's what I am submitting also.
What about annexure A?
Annexure A, not only that, your lordship may be pleased to see annexure A, bottom your lordship says, they asked me to pay the 1,000.
Establish your title in before the civil court.
Then ultimately whatever your lordship directs, we are obeyed. 1 minute your lordship may be, whether it is necessary to send or not, I'll convince you.
But no, the respondent has disputed all the documents.
Let us, only because they dispute it, your lordship need not send it. The material available at all says it must be the case to be sent to the civil court. I have no objection at all. But I'll now demonstrate before your lordship, one by one. First, the annexure A, your lordship may be pleased to see. Yes. This, the man signed, same in annexure B also, same signature at the end.
Your lordship, it is not the same, sir.
Small initial. Then we have paid the money in pursuance of this. They never disputed they have received this money in pursuance of this. See their objection statement. When they are not disputed, that the Supreme Court said the court should draw the adverse inference and under section 58 of the Indian Evidence Act, it is proved. They never, otherwise why should they take it, this money? All right, up to this state, did they say, no, by mistake, even another $5,000, 500 also they have received it. They gave a sanction plan. Let us see, my lord. They themselves, what the answer in the objection statement, very interesting answer. They don't say it is not their signature, that is not the plan sanctioned by them. On the contrary, what he says is, para 4 of the objection statement, it is submitted that annexure the purported to be the plan of the petitioner does not indicate any details of the allotment or details regard to the individual in whose name it is. In any sanction man, would they write like that, my lord? This is the first time I am hearing. Only thing is when there is a document to certificate is position certificate is given in pursuance of that application file, it is granted. They don't dispute sanction plan is granted. They don't dispute I have constructed the 7 square built up area. They don't dispute even 1970 2000, sorry, 1 minute, I'll give the date. The Kata also reached when it is reached.
There is a serious dispute regarding.
In your lordship says, after the all construction is over, 99, 98 itself, the assessment is made for the whole building. Thereafter, I paid the assessment. Earlier, along with my writ petition, I have produced some receipt. Now, your lordship kindly see the rejoinder. Up to what period I have paid it?
Yes.
Amount up to date, that is about 21, 22 up to date, I have paid it. If really they have cancelled my registration of Kata in my
What is there to show that you have paid this money? What is there to show that you have paid? Where's the receipt?
Your lordship kindly rejoinder, your lordship kindly rejoinder. I filed a rejoinder along with all annexures I filed before your lordship.
Rejoinder.
Rejoinder, along with all documents your lordship see. The number 8 is what they is absolutely first, because they once again they are written a letter that about this allotment of mine. Then annexure J, your lordship may be pleased to see. Kata is registered in my name. 99, 98 tax is received up to 2001, 2012. Then your lordship see the next receipt. There is also Kata is paid 2001, 2002. Then the next receipt 2007 to 2008, 2008 to 2009. Like all the taxes paid. And next receipt 2009 to 2013, 14. All the 5 years taxes paid.
So what is there to show? What is there to show that you have paid this 1,000 rupees or 2,000 rupees?
1,000 rupees. First.
Sir, what is there to show that pursuant to annexure B, you have paid the money to the council or corporation?
Annexure ಹೆಂಗೆ ಎಂಡ ಕೆಳಗೆ ಹಾಕಿದೆ ನೋಡಿ. ಏನೆಲ್ಲ ಕೆಳಗಿದೆ ನಾನು 1,000 ಕೊಟ್ಟಿರೋದು. ಚಲನ್ ಎನೆಕ್ಸ್ ಮಾಡಿದೆ. ಎನೆಕ್ಸ್ ಹೆಂಗ ಒರಿಜಿನಲ್ ನೋಡಿರಿ ಇದೆಲ್ಲ ಕಡೆಗೆ ಟೈಪ್ಡ್ ಕಾಪಿ ಅಲ್ಲ.
Annexure B ನಲ್ಲಿ ಪ್ಲೀಸ್ ಲಿಸನ್ ಟು ಮಿ. Annexure B ನಲ್ಲಿ 10ನೇ ಬ್ಲಾಕ್ ಪ್ಲೀಸ್ ವೈಟ್ 10ನೇ ಬ್ಲಾಕ್ ಪ್ಲೀಸ್ ವೈಟ್ ಸರ್ ಒಂದು ನಿಮಿಷ ಹೇಳಿ. ಪ್ಲೀಸ್ ಲಿಸನ್ ಟು ಮಿ ಸರ್. 10ನೇ ಬ್ಲಾಕ್ ನಲ್ಲಿ 42ನೇ ನಂಬರಿನ ನಿವೇಶನವನ್ನು ಚದರಡಿ ಒಂದಕ್ಕೆ 10 ರೂಪಾಯಿ ಅಂತೆ ಬೆಲೆ ನಿರ್ಧರಿಸಿ ಠರಾವು ಮಾಡಿರುತ್ತೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಸರ್ಕಾರದ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಈ ಕೂಡ ಲಗತ್ತಿಸಿದೆ. ಇದಾದ್ಮೇಲೆ ಯು ಆರ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಡೆಪಾಸಿಟ್. ವೇರ್ ಹ್ಯಾವ್ ಯು ಡೆಪಾಸಿಟೆಡ್?
ಫಸ್ಟ್ annexure A ತಗೊಳ್ಳಿತ್ತು. annexure A ಹೆಂಗೆ ನಾನು 3 ದಿನದೊಳಗೆ 1,000 ಕಟ್ಬೇಕನ್ನ ಮಾಡಿ ನೋಡಿ. ಅಲ್ಲಿ ಕೆಳಗೆ ಫಸ್ಟ್ annexure A ಒರಿಜಿನಲ್ ಇದ್ರೆ ಕೆಳಗೆ ನೋಡಿ ರಿಸಿಟ್. There is a challan, not even cash ಕೊಟ್ಟಿದ್ದೀನಿ ನಂದೇನಿಲ್ಲ. There account Axis Bank I had deposited you 1,000.
ಪಾವತಿ ಮಾಡಬೇಕಾದ ಮೊದಲನೇ ಕಂತು 1,000 ರೂಪಾಯಿ ಎಲ್ಲಿ ಪಾವತಿ ಮಾಡಿದ್ದೀರಾ? ಬೇರೆ
1,000 ರೂಪಾಯಿನೇ ಕೊಟ್ಟಿರೋದು. ಇನ್ ಬ್ಯಾಂಕ್ ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್ ಇನ್ ದೇರ್ ಅಕೌಂಟ್.
ಎಲ್ಲಿದೆ
ಈ ರಿಸಿಟ್ ತಮ್ಮ ನೋಡಿ. annexure A ಒರಿಜಿನಲ್ ತಗೊಳ್ಳಾಯ್ತು. ಕೆಳಗೆ ಬಾಟಮ್ ಆಗಿದೆ ನೋಡಿ.
annexure A is a notice.
ಅದೇ ಅದರೊಳಗೆ ಕೆಳಗೆ ನೋಡಿ ತಾವು.
ಆಯ್ತು, ಕೆಳಗಡೆ ಬ್ಲಾಕ್ ನಂಬರ್ 42 ಸೈಟ್ ನಂಬರ್ ಸೋನ್ಸೋ ಕಿಮ್ಮತ್ತು ಮೊಬ್ಬಲಗು ಪಾವತಿ ಮಾಡಬೇಕಾದ ಮೊದಲನೇ ಕಂತು 1,000 ರೂಪಾಯಿ.
ಅದ್ರ ಕೆಳಗೆ ರಿಸಿಟ್ ಇನ್ annexure ಹಾಕಿದೆ.
ಏನ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಸರ್. ನಾಟ್ ಹಿಯರ್.
ನಾನು ನಂದ್ರಂಗೆ ರಿಸಿಟ್ ಕಂಪ್ಲೀಟ್ ರಿಸಿಟ್ ಇದೆ. ಅವ್ರ ಹತ್ರ ಎಲ್ಲ ಕೇಳ್ತಾರೆ.
ಏನೇನು ರಿಸಿಟ್ ಏನಿಲ್ವಲ್ಲ.
ರಿಸಿಟ್ annexure ಹಾಕಿ ಇದು ಹಾಕಿದ್ದೆ ನಾನು.
ನಮಗ್ ಕೊಟ್ಟಿರೋದೇ ಬೇರೆ, ನಿಮ್ಮ ಹತ್ರ ಇರೋದೇ ಬೇರೆ.
Sorry, I will produce it. If such is the case, I am sorry. ಈಗ ನನ್ನ ಹತ್ರ ಇರುವುದು ಇಲ್ಲಿದೆ, ಕ್ಲೀನ್ ಆಗಿ ಇದೆ. ಎಕ್ಸಿಸ್ ಬ್ಯಾಂಕಿಗೆ ಕಟ್ಟಿ 1,000.
ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. What about this?
Produce it,
ಎಲ್ಲ fraud on thing. So much of records are built up. There are ministry ಯಾರು ಲೆಟರ್ ಬರೆದಿದ್ದಾರೆ. ಆಯ್ತು ಇರ್ಲಿ. What about the other documents? 1,000 ರೂಪಾಯಿ ದುಡ್ಡು ಕಟ್ಟಿದ್ದಾರೆ. The government permission ತಗೊಳ್ಳದಂಗೆ could have been a layout that is formed by you. Scheme ಮಾಡಿಲ್ವಾ? 165 Municipalities Act.
Dimension of this also is 10/4. But we have cancelled that. That's the Allotment.
Actually, Allotment ಪ್ರಕಾರ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದೀರಾ? Actually,
ನಾವು R1 ತಗೊಂಡು ನೋಡಿ ಏನ್ ಮಾಡೋದು ಅದೇನು 6 ವರ್ಷದ ನಂತರ ನಾನು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ 6 ವರ್ಷ ಆದ್ಮೇಲೆ not earlier. The petition is pending when stay order is there. This one, even what is that they have said, your lordship kindly see.
Then you either go before the civil court. We can't decide it.
No, that's why I want to make a small statement.
You can't decide whether this document is genuine or not.
Certainly will obey the order. No, one submit legal position. I will submit my legal position. ಅದು ಒಪ್ಪಿದ್ರೆ ತಾವು ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು ಅಲ್ಲದೆ ಮತ್ತೇನು ತಮ್ಮ ಉಪದ ಕೊಡಲ್ಲ ಇದ್ರಂಗೆ. ನಾವು admittedly sanctioned I had opportunity there. They never disputed it.
Nothing is admitted.
So for payment of the deposits, so for payment of the rent is concerned, they never disputed. The last one kindly see their objection, whatever he says his objection, never disputed. Receipt of the rent also. And so far the sanction plan, he never disputed. Plan is not given, but he says particular of allotment is not mentioned there. Nowhere in the sanction plan particulars of the allotment will be shown. Then undisputed, I have constructed 7 acres, 7 plus building, and in all receipts, then your lordship says
correct. But where have we mentioned about in the petition?
Now, how do you tackle request your objections?
Deposited ₹1,000 and obtained a receipt. Adelle deny ಮಾಡಿದ್ರು.
Next year itself is 4.
₹1,000 ರೂಪಾಯಿ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದ್ರು? ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
Next year encompasses this receipt.
Deposit ಅದ್ರ ಮೇಲೆ ಇನ್ನೊಂದು 500 ಮಾಡಿತ್ತು, ಅದನ್ನು ಹೇಳಿಲ್ಲ. One thing ಅಲ್ಲ, having received the taxes right from 1998 up to now, even after the LH cancel, they have received it. LH cancel, they have received.
Economically backward community 10 by ಎಷ್ಟು 10/14 ಗೆ ಇದೆ ಅಂತ ಎಷ್ಟು 30/40 30/35 The petitioner has sought for a writ in the nature of mandamus to direct the respondent to issue to execute and register a deed conveying the site bearing number 10 formed in 42nd block, Hunasinakere extension, Hassan. Next, the petitioner claims that she hails from an economically backward community and that neither she nor her family members possess any property, any immovable property in Hassan. To stop. She applied for an allotment of a site by filing an application on 5/5/1988. To stop. Pursuant thereto, the respondent called upon her to deposit a sum of ₹1,000 as the first installment and a sum of ₹500 towards the next installment. The petitioner claims she deposited the same and obtained a receipt. Full stop. Later, the respondent allotted site number 10 in block number 42 of Hunasinakere extension. And in full stop. The respondent also intimated the same to the concerned authority of the state government on 26/3/1994. The petitioner claimed that she also deposited the second installment of ₹500. Whereafter, the possession of the property is delivered to the petitioner in terms of the possession certificate, dated nil. Full stop. It was mandated in the possession certificate that the petitioner should put up construction within a period of 2 years, and accordingly, 2 years. Full stop. It was also required that the petitioner should deposit a sum of ₹10 per square feet as the sale price. Pursuant thereto, the petitioner obtained a loan and constructed an RCC building in the said site in an area measuring 750 square feet. The building so constructed was assessed to tax, and that the petitioner has been paying the tax till date. However, the respondent has not concluded the allotment by executing a deed of absolute sale, and therefore the petitioner is before this court seeking for appropriate directions. The respondent has objected to this petition, contending that the petitioner was not allotted any site by the respondent, and that the documents relied upon by the petitioner are all fabricated for the purpose of laying a false claim to the site in question. It is also claimed that the Kata that was entered in the name of the petitioner was subsequently cancelled in terms of an order dated 11/3/2019, and that the petitioner has not challenged the same in accordance with law. Third counsel representing the respondents submitted that each of the documents, including the receipt receipt under which the petitioner deposited a sum of ₹1,000 into the account of the respondent, were all forged and fabricated for the purpose of the case. Therefore, submits that this court not exercise jurisdiction under Article 226 of the Constitution of India to grant the reliefs which the petitioner is bound to secure at the hands of the civil court. Next paragraph.
With apology to your lordship.
Yes, sir.
For fact is concerned, let us be correct. Tax is paid for 2001 also. Though they say that Kata is cancelled in 2019, even up to 2001 tax is paid. I have produced the receipt before your lordship.
2001 comes
for a fact purpose.
2001 comes before 2019.
19 cancel 2001 tax ನನ್ನ ನಿಮಗೆ
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರೆ 2001 ಅಲ್ಲಿ ಕಟ್ಬೋದಲ್ಲ 2001
ಇಲ್ಲ ಟ್ಯಾಕ್ಸ್ ನೇಮ್ ಇರುತ್ತಲ್ಲ ಹೆಸರು ಓನರ್ ನೇಮ್ ಎಲ್ಲ ಇರುತ್ತಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದು ನೇಮ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇಟ್ಟಲ್ಲಿ
ಅಲ್ಲ ಸರ್
ಅಲಾಟ್ಮೆಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇಟ್ಟಲ್ಲ 2001
cancel
No, your lordship is what I am trying to convince your lordship is If they have cancelled my name, they say only Kata is cancelled, not the allotment. Kata is cancelled, they said. All right, Kata is cancelled in 2019. How can they issue a tax even subsequent to that? That's all what I want. Actual position.
After 2019.
2001, yeah, regender,
2001 comes before 2019, sir.
I'll show you last. You know what? 6th June 2021, last
21 ಅಂತ ಹೇಳಿ ಮತ್ತೆ 2001 ಅಂತಿದ್ದೀರಾ?
ಅಲ್ಲ 2021 ಅದಕ್ಕೆ ಕ್ಯಾನ್ಸಲ್ 19 ಅದೆಲ್ಲ ಕೊಟ್ಟಲ್ಲ ಅಪ್ ಟು ಡೇಟ್ ಕಟ್ಟೋದಕ್ಕೆ ಎಲ್ಲ ರಿಸಿಟ್ ತೋರಿಸಿದೆ ನಿಮಗೆ. ಇದು 2021.
From annexure B that seen from annexure B that the name of the petitioner is found as the name of the petitioner is shown to be the name of the petitioner appears as the municipal commissioner of the respondent. It is not known whether in March 1994 the municipal commissioner of the respondent also carried the same name as that of the petitioner. Full stop. The signature found in annexure B of purportedly to be the signature of the municipal commissioner closely resembles the signature of the petitioner herein, which is evident from the wakalat file. Full stop. Annexure C does not disclose the date and the person who had issued the possession certificate and the name of the person to whom it was issued. Annexure D, which is purportedly to be the plan of the site in question, is also disputed by the respondent. Also disputed by the respondent. The respondent claims that the name of the petitioner, which was entered in the assessment register was based on an assertion that the petitioner was allotted the land and thereafter the petitioner is paid tax under the self-assessment scheme. Full stop. Joint counsel submits that the kata that stood in the name of the petition was cancelled, and therefore there is a genuine doubt about the title of the petitioner. Full stop. As rightly contended by the learned counsel for the respondent, the proceeding under Article 226 is not a panacea for all ills, and therefore this court cannot assume the jurisdiction of a civil court in deciding the title of the petitioner to the property in question. Next paragraph. However, having regard to the fact that the property in question is a small residential site measuring 10 meters into 14 meters, it is appropriate that the respondent has a relook at the records of the petitioner and thereafter decide as to whether the petitioner is entitled for obtaining a deed of absolute sale in respect of the site in question. In that way of the matter, the petition is disposed of, directing the petitioner to approach the respondent with all documents in original Full stop. The respondent shall thereafter consider and dispose of the claim of the petitioner in accordance with law. Full stop. The petitioner shall appear before the respondent on what date? 30th June 2022.
Some date in June, Your Lordship.
And the respondent shall pass appropriate orders within a period of by 30th July 2022.
30th July.
Yes. Yes.
Alternate side subsequently, in the year 2014, but can you tell us reached 27 months actually? The second respondent was passed a resolution. Followed was scheduled the property was in favor of the. However, pursuant to the resolution was second respondent no action was taken by the party. The executive was commenced the petitioner. Representation was addressed. When was the date was the second respondent was municipality has not taken any action.
When will you do it? Management. When will you allot? The petitioner is sought for a direction to allot alternate site as per the resolution of the respondent number 2, dated 1/3/2014. In lieu of the site in lieu of the utilization of the site belonging to the petitioner for the purpose of widening the road. Full stop. The learned counsel for the respondent number 2 does not dispute this fact, but contends that the respondent number 2 is prepared to allot a site, alternate site. Please wait, madam, as an alternate site, and that alternate site and raise 2 weeks time to comply with the same. So when will you do it? Please pick a date. The calendar is there.
Hmm.
17th, you should come up with an allotment. Don't come and again ask for time or file objections. List on 17th. The three shares agreed of next. Huh? Who appears for the response? Authority. City Municipal Council, Polar.
I appear for the respondent municipality, my lord.
You are for the council, municipality. Yaar ಮಾಡ್ತಿರೋ? Who is doing? Is it the municipality or the municipal corporation? You can call it municipal corporation. No, it must be a corporation.
Town municipality. City municipality, my lord.
CMC.
CMC, my lord.
Oh, I think it must be upgraded to a corporation, isn't it?
No, my lord, still it is not.
Yes, what is your, you're saying that you can use it only in due process of law.
Yes, my lord.
You can
Another
utilize the
another connected matters 4437 of 2015, my lord. The court has passed a judgment, my lord, where in this matter, my lord, they have only taken the time stating that one petitioner is dead.
No, Mr. But here, if you want to acquire the property of the petitioners for the purpose of road widening or for any other activity, you acquire it in the manner known to law.
Yes, my lord. Yes, my lord.
And simply barge into somebody's property and demolish it. Purple.
My lord, they have submitted, my lord, in the last occasion, one submission, my lord. In the last occasion, they have submitted that one petitioner is expired. I don't know, my lord, which petitioner it is expired, my lord.
The oldest man in this list of petitioners is Pandurangaya Shetty. Yaar tirogidari?
They have only expressed, my lord. Henceforth, it has been delinked with the other two matters, my lord.
Who has expired, Mr.? Huh? Passover. Tell notice. Passover.
Lordships, kindly one submission.
Number?
Serial number.
Counsel for the petitioner submits the process is paid. Office to check, verify, and proceed. To issue notice to the answer response. Number 25. Learned counsel for the petitioner submits the copy of the petition is served to the learned counsel for the respondent.
My lordship, serial number 17, my lordship.
Issue notice to respondent number 4. The process is paid during the course of the day. The process is not paid. The process is not paid. The petition against respondent number 4 shall stand rejected. Yes, courteous.
One submission.
My lordship, serial number 17, my lord.
Please wait. Lawyers on the VC, please wait. The number? Petitioners counsel. The request of the counsel for petition is on. It's on 10th June. Yes. Yes.
Serial number 70. One accommodation, David Kodis. Kindly call it on 7th. I will come and argue. I'm not well.
The request of the counsel for petition list on 7th. Yes.
Grateful.
Serial number 17, my lord.
17.
I shall pay the process today, my lord, after lunchtime. 17.
Counsel for the petition undertakes to pay the requisite process and furnish other requisites to issue notice to the respondent number 2 during the course of the day. If the process is paid, office is directed to proceed to issue notice. If the process is not paid, the petition against respondent number 2 shall stand dismissed.
Much obliged.
My lord, my submission, my lord.
This?
My lord, serial number 30, my lord. I'm for the petitioner in this matter, my lord. Senior out of station either, my lord. Kindly have it on short accommodation, my lord.
Please wait.
Number 14. Number 14. Tina PK.
This time is granted to take out, to pay process other requisites. To issue notice to respondent number 3, dealing with the petition against respondent number 3, to stand dismissed without reference to them.
Number 15. 30.
This time is granted to amend the cost statement.
Number 16. Mahesh.
ಯಾವ R4 ಯಾವ ರೀತಿ ಇರೋದು R4 ಯಾವ ಇರೋದು number 16 ಅಲ್ಲಿ 2 weeks time is granted to take to pay process and other and deposit other requisites to issue notice to respondent number 3 and 5. If process is not paid, the petition against respondent number 3 and 5 shall stand dismissed. Next, the notice issued to the respondent number 4 returned unserved with an endorsement that the respondent number 4 has expired. To stop. The returned cover was received in the office, was received in the registry on 18/3/2017. However, steps are not taken till date to bring the legal representatives of R4. Hence, the petition against R4 has abated. Yes. Counsel for the petition submits that the process is paid. Office to check, verify and proceed. 2 weeks time is granted to pay process to issue notice to respond number 3 and 4. Process is not paid, the petition against the said respondent shall stand dismissed. Counsel for the petition submit to the process and other requisites are paid. I thought notice ಹೋಗಬೇಕಲ್ಲ issue ಮಾಡಿದ್ದೆ ಮೇಲೆ. Why did you allow notice to be issued then? ಅವತ್ತೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. The process is in order, office is directed to issue notice. ಯಾರು BBMP ಕೊಡ್ಲಿಲ್ಲ ಜನ ಯಾರು BBMP ಯಾರು only BBMP ಇನ್ನ ಬೇರೆ ಇದ್ದಾರ ಇದನ್ನೇ private respondent TV Muralidhar is directed to accept notice for respondents 1 and 2. Counsel for the petition is directed to serve copies of the writ petition on the learned counsel for the respondents. Counsel for the petition submits a notice to that the copies of the writ petition is served to the learned counsel for the response 1 to 3. List after service of notice to respond number 6 and 7. Yeah, 6 and 7. When trial court is there, is there any proceeding before the trial court? Put it there. Page number? Who is the advocate for the respondent 6 and 7? They are advocate. So HR Anantha Krishnamurthy. So HR Anantha Krishnamurthy is directed to accept notice for
Respondent number 6 and 7. Counsel for the petition is directed to serve copies of the petition to Sri HR Anantha. Yes. The Krishna Naik, Subramanya R. Narayan, but there is no representation for the petitioner and the respondent.
My lord, I appear for the respondent number 4, my lord. My
Ah.
lord, I have filed this application, my lord, for vacating the interim order.
Yes.
My lord, license is not continued. Despite without license, my lord, the petitioner is carrying on the business in the said shed. Your lordship, my lord, in the morning had asked the petitioner to make a statement whether the license has been renewed or not. That's why, my lord, it was passed over.
Yes. Where is the counsel?
My lord,
Counsel
they
for
are
the Krishna Naik.
if your lordship peruses the order sheet, my lord, every time, my lord, they were taking time, even in the past. My lord, right in front of my showroom, this shed has been put up in violation of the sanction plan. My lord, there is no such premises, my lord, as per the sanction plan. This is a building of the Red Cross.
Yes.
My instructions are that, my lord, license issued to them was not renewed.
Krishna Naik. What are your observations about this? Correct, Mr. What have they filed any application for trade license as per Annexure C? What has happened to the trade license? Have you considered? As of now, there is no license. ಅದೇ ರಿನ್ಯೂವಲ್ ಆಗಿದೆಯಾ ನಿಮ್ ಪ್ರಕಾರ ಅಲ್ಲಪ್ಪ ರೆಸ್ಪಾಂಡೆಂಟ್ ಪ್ರಕಾರ IA orders on IA 2 of 2019. This quote in terms of the order dated (19 to 2019). Had stayed the notice issued by the respondent number 2 dated 12 to 2019 for a period of 6 weeks, which is thereafter continued from time to time. Stop. This application is filed now by the learned counsel for the respondent number 4. It contains that the petitioner is operating the chart center without obtaining any license from the respondents 1 to 3. Full stop. The respondents 1 to 3, the learned counsel for the respondents 1 to 3 submits that the petitioner is not, submits that the petitioner is operating chart center without obtaining the trade license, and that the one obtained by the petitioner expired in the year 2019, which is not renewed thereafter. Full stop. This resolution was listed on 23rd May 2022, so as to enable the learned counsel for the petitioner to secure instructions whether the petitioner has obtained trade license to run the chart center. Stop. Even today, the learned counsel for the petitioner, the case was passed over in the morning session so as to enable the petitioner to obtain instructions. However, the current counsel for the petition is absent. Stop. In that way of the matter, comma, the order dated 19/2/2019 is vacated. It is open for the respondents 1 to 3 to proceed from the stage of hearing the petitioner pursuant to the notice dated 12/2/2019 and pass appropriate orders. Counsel for the petitioner seeks time. Oral relevant urgency. List on 10th June. Yeah.
39.
Yes. Karnataka ಇಲ್ಲಾಂದ್ರೆ ಏನ್ ಮಾಡೋದು? Request of the counsel for the petitioner ಯಾವತ್ತು ನೀವ್ ಹೇಳಿ ಕರ್ನಾಟಕ ಯಾವತ್ತು ಸಿಗುತ್ತೆ ಹೇಳಿ ನಾಳೆ tomorrow. What is the date? Fair enough. Let the authority hear the petitioners and pass appropriate orders. Very good. The petitioners have sought for written the nature of certiorari to quash the order dated 22/11/2011 passed by the respondent number 2 and to direct the petitioners and direct the respondents to pay cost of the proceedings of this proceeding. As per the petitioners claim that they were all allotted sites under the scheme called by the state government to commemorate the 25th year of Indian independence. Stop. The said allotment was challenged by the respondents 5 and 6. Respondents 5 and 6 before the respondent number 2. Stop. The respondent number 2 in terms of the order dated 22/11/2011
allowed the appeal and set aside the grant of sites to the petitioners and others. Stop. The petitioner further submit that they had filed separate suits against the respondent number 5 and 6 for perpetual injunction, for perpetual injunction, and that the same were all decreed. Stop. It is claimed that the respondent number 2, without conducting the proceedings regularly, had passed the impugned order without hearing the petitioners and without providing them an opportunity to place on record the relevant material documents to establish their claim to the sites that were allotted. Etc. The learned counsel for the respondents 5 and 6 submitted that though the petitioners were notified of the proceedings, for the respondent number 2, the learned counsel for the respondent number 2 submits that though the petitioners were notified of the proceedings, but yet the petitioners did not produce any documents, and therefore, based on a report requisitioned from the office of the Tahsildar, from the office of the Panchayat, dated 1/10/2011, the respondent number 2 has proceeded to decide the case. What about response 5 and 6? Devaraju HK. Next para. The perusal of the order sheet maintained by the respondent number 2 discloses that the petitioners were never notified of the proceedings. As a matter of fact, the appeal by the respondents 5 and 6 was filed before the respondent number 2 on 5/7/2011, and the first date of hearing was fixed on 14/9/2011. On 4/8/2011, and thereafter on 14/9/2011. But there is nothing on record to establish that the petitioners were ever served with the notice of the proceedings. Stop. In that way of the matter, the impugned order passed by the respondent number 2 is clearly without following the principles of natural justice, and therefore the same deserves to be set aside on this short ground alone. Consequently, this petition is allowed in part, and the impugned order is passed by the respondent number 2, dated 22/11/2011, is set aside, is quashed, is stopped. The respondent number 2 is directed to rehear the petitioners.
May I submit?
Yes.
Only in so far as petitioners are concerned, only 3 petitioners are there.
Petitioners are there.
Only regarding petitioner.
The petitioners, insofar as the petitioners are concerned, the respondent number 2 shall hold fresh proceedings and hear the petitioners and pass appropriate orders. In order to enable the respondent number 2 to hear the petitioners, they shall appear before the respondent number 2 on 30th June 2022 at 3 p.m. ಮೂರು ಜನ ಇಲ್ಲ ಅಂದ್ರೆ ಮೂರು ಜನ ಸತ್ತೋಗಿದಾರ? All 3 of them are dead. 1 and 3. Then take steps, madam. Counsel for the petitioner submits the petition number 1 and petition number 3 have expired, and that steps would be taken to bring the legal representation on record. Four, the plan to do the need. Four hundred and? ಎಷ್ಟನೇ ಇಸ್ವಿನಲ್ಲಿ 1976. So when was the acquisition? 76.
For the organizing side, second fourth respondent. If you can order no action has been taken with the fourth respondent.
Yes. ನೀವು ಯಾರಿಗೆ? No. If the land is, if the acquisition is set at naught, you are bound to execute allot alternate site. Other lane. So where's the question of returning the did he pay the money to take it back? He paid the money to take a site. No sites alla. Then we'll ask you to furnish all the illegal layout ಎಷ್ಟು ಮಾಡಿದ್ದೀರಾ ಕೊಡಿ ಹಂಗಿದೆ. No. So you furnish the details. How many layouts, how many sites are formed, how many sites are allotted, in a site with ಕೊಡಿ. No, we will not take your affidavit. Please furnish all the details. How many acres of land is acquired? How many sites are formed? How many sites are allotted? Kodi. So you might take. So it is convenient for you to take a stand. It is convenient for you to take a stand. But please establish your stand. Produce what? Circle. The learned counsel for the respondent number 4. No, how will the petitioner know? ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ ಹೆಂಗೆ ಗೊತ್ತಾಗುತ್ತೆ? You heard the CM, the Chief Minister saying, he said, even I cannot find out the stray sites in Bangalore city. This is what the Chief Minister said. The learned counsel for the respondent number 4 seeks time to ascertain whether there are any sites available for allotment to the petitioner. So, next para.
the request of the learned counsel for the respondent number 4 is granted. However, if the respondent number 4 does not come up with a solution to the problem, the respondent number 4 shall place the details of the land acquired, details of the layouts lying within the limits of the respondent number 4, and whether and the details of the allotment of the sites in such layouts by the next date of hearing. When do you want? List on 15th.
I appeal for respondent 1 and 2, my lord. The application, kindly see the prayer, my lord, page 19, Atomatu. They are seeking quashing annexure, yes. Where we have rejected their application for grant of license. Against that, they prefer the appeal. Annexure, yes, page 68.
Yes. Paying guest ಉದ್ದಿಮೆ ಸಂಸ್ಥೆ ಸ್ವಯಂ ಇಚ್ಚೋ ಬಗ್ಗೆ
They have entered into an agreement of lease of property for only 11 months.
Yes, who appears for the petitioner? Stay there.
Although I have made an application for vacating in the year 2016, my lord. And moreover, he has filed an appeal before the standing committee, Annexure T, page 70.
Annexure P.
T. Page 70. 70. And he has approached the Honorable Court also.
What is the date of Annexure P? Date?
Annexure T, adu
the Annexure P is a notice issued by the health officer to close down.
RST.
T.
70, page 70.
What is challenged before the standing committee?
Same annexure, yes.
Standing committee function ಆಗ್ತಿದ್ಯಾ?
ಈಗ commissioner is having power. Administrator is having power of the committee. Actually, our administrator ಮುಂದೆ ಹಾಕ್ಬೇಕಾಯ್ತು. ಆವಾಗ ಅದಾಗ್ತದೆ 2016.
Learned counsel for the petitioner has challenged the notice issued by the notice dated 14/11/2015 issued by the respondent number 2. Directing the petitioner hearing to close the paying guest accommodation since the landlord or landlady?
Landlady.
Since the landlady of the premises had opposed the extension of the license to operate the paying guest. Stop.
Not extension, to grant the license.
Extension to grant the license. Grant the license. Stop. The learned counsel for the respondent number 1 and 2 submits that the petitioner has already approached the standing appeal committee under section 444 of the Karnataka Municipal Corporations Act, and therefore the petitioner may be relegated back before the standing appeal committee. The learned counsel for the response 1 and 2 further submits that the standing appeal committee is now functioning, and therefore the petitioner can escalate his grievance before the appeal committee. Seek redressal of his grievance. Seek redressal of his grievance before the appeal committee. Stop. There is no representation for the petitioner. Nonetheless, in view of the submission made by the learned counsel for the respondent 1 and 2, the petition is disposed of, permitting the petitioner to approach, permitting the petitioner to pursue the appeal filed by him before the standing appeal committee. Will stop. The impugn notice. Since this court had granted an interim order of stay of the impugn notice, the said benefit, the interim order shall be extended for a period of 1 month from today.
One request, my lord, one request. Till 2000, till today, from 2016, he has not obtained any license. The interim order cannot be continued.
All contentions are left open.
Obliged.
In view of the disposal of WP, IA 1 of 2016 for vacating fee does not survive for consideration.
The interim order not extended, my lord. It is not obliged.
Pardon? Yeah, restitution, what is it about? Respondent 4, huh? Counsel for the respondent number 4, 8 years since time to file objections. Based on 16th June. Yes. Kata is not being issued. Property tax has been paid. Section A has been issued. That page 12. Another postponed order 2017 and 1890. Interest portion is being distributed in NA 14 of 2020. They are issuing an endorsement saying that go get that dispose of only then we will give you certified Kata. I is a commercial building. I have been issued occupation certificate back in 2017, page 15. I am among the 2 commercial buildings in the area that are fully compliant. I got an occupation certificate.
I started paying taxes not from 17 and 18. That is at page 18.
ಇತ್ಯರ್ಥವಾದ ನಂತರ ಅದರ ಅಂತಿಮ ಆದೇಶ ಪ್ರತಿ. What is that? Correct. Please read that the condition mentioned in Annex A. ಅಂದ್ರೆ ಏನು? Why should that be produced? Matter is pending before an appeal.
I have paid the under protest and deposit to the firm. 90 lakhs was demanded or something. I paid that.
If you succeed in the appeal, he is going to pay the interest. Interest. This is what- Reconsider.
Yes.
Purple. What is this individual subdivided katas in respect of
Commercial building, my building has got the Kata as soon as the occupation certificate for issue. The building has got Kata. For each of the units in the building which I may either lease or sell, I need subdivided Katas. How numbering is.
ಇದು ಗಾಂಧಿನಗರದಲ್ಲಿದೆ, ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಮಾಡ್ತಿದ್ದಾರೆ. The building is in Gandhinagar.
My lord has got a point.
Purple. The petitioners have sought for a direction to the respondents to issue subdivided katas in respect of their individual units of the commercial premises of the property bearing number. What is this? Bearing number 12, 69 Gandhinagar, Bangalore. Full stop. The petitioners claim that petition number 1 to 9 are the co-owners of the aforesaid land, which was developed into a commercial complex in accordance with the plan sanctioned by the respondents. Full stop. Later, after the completion of the construction, the building was inspected and an occupancy certificate was granted. Full stop. The property was assessed to tax and a separate property identification number was issued. Full stop. The petitioners for paying the tax online, paying the property tax online. Full stop. When things stood thus, the respondents issued a notice dated 18/6/2019 revising the assessment of the land and building with retrospective effect and demanded a revised property tax of rupees 45,73,740 per annum. The petitioners deposited the revised property tax under protest and protest till the second half of 2020-21. Later on 27/8/2020, the respondents issued a show cause notice to the petitioners demanding arrears of property tax for the years 2017-18 and 18-19, together with interest at the rate of 2% per month. So the petitioners replied to the show cause notice, stating that they had paid the tax demanded by the respondents for the year 2017-18 and 18-19. Yet, the respondents issued a demand notice dated 22/9/2020. Feeling aggrieved by the aforesaid demand, the petitioners have filed MA number 14/2020, challenging the alleged illegal demand for the demand of property tax for the years 2017-18 and 2018-19, along with interest at 2% per month. The said appeal is pending consideration before the court. In the meanwhile, the petitioner submitted a representation requesting the respondent number 2 to issue subdivided khatas for the individual units. Full stop. The respondent number 2, without any application of mind to the request, issued an endorsement dated 6/2/2021, calling upon the petitioners to produce certain documents, one of which was the final order to be passed in the MA 14/2020. To stop. It is this that the petitioner is aggrieved and submits that the decision in MA 14/2020 submits that the subdivided khatas submits that issuance of the subdivided khatas has nothing to do with the disposal of MA 14/2020, which is purely an accounting exercise to identify whether the petitioner is liable to pay the property tax for the year 2017-18, 18-19. Full stop. The learned counsel for the petitioners submits that this demand by the respondent number 2 is only to harass the petitioners. Full stop. In reply, the learned counsel for the respondents submitted that respondent number 2 submitted that the petitioners have defaulted in payment of the property tax and therefore cannot seek for any, therefore cannot obtain, therefore are not entitled to the subdivided khatas of the commercial units. Next para. The appeal filed by the petitioners before the district judge in MA 14/2020 is an exercise of their statutory right under the Karnataka Municipal Corporation Act 1976. Full stop. The respondent number 2 has already assessed the property tax, and the petitioner has claimed that it has paid the property tax up to the second half of 2020-21. So the issue whether the petitioner is liable to pay the property tax for the years 2017-18 and 2018-19 is sub judice before the district court in MA 14/2020, and this cannot at any rate disentitle the petitioners for obtaining the subdivided kata in respect of the commercial units in the premises in question. In that way of the matter, the writ petition is allowed, and the respondent number 2 is directed to forthwith issue the subdivided Kata in respect of the commercial units in the aforesaid premises within a period of 4 months, within a period of 1 month from the date of receipt of a certified copy of this order. It is needless to mention that the petitioners would be liable to pay the property tax as may be determined in MA 14 of 2020. Ground rent ಆಗಿದೆಯಲ್ಲ. Spending in dividend, that is the state. These are only ground rent. Lake rejuvenation says ground rent. MRTS was not the subject matter of the writ petition. MRTS take ಹೇಳಿಲ್ವಾ? ಆಯ್ತು, ಅದನ್ನ ಡೆಪಾಸಿಟ್ ಮಾಡಿ. Subject to the Tenant counsel for the petitioner submits that the coordinate bench of this court has held that the respondents are not entitled to demand and collect the scrutiny fee, lake rejuvenation, cess, ground rent, ಇನ್ನೊಂದೇನೋ ಇತ್ತಲ್ಲ, 4 ಇದು ಲೈಸೆನ್ಸ್ ಫೀ, security scrutiny fee, scrutiny fee. Full stop. You would submit that the petitioner would deposit the submit that to deposit the mass rapid transport system charges of ₹7 lakhs to you deposit the demands made by the respondent, excluding the aforesaid. Full stop. The learned counsel for the respondents, on the other hand, submitted that the judgment of the learned single judge of this court is stayed by the division bench of this court. In that way of the matter, the petitioner, the impugned demand at Annexure A dated 11/1/2022 is subject to the petitioner depositing all other demands except scrutiny fee, license fee, lake rejuvenation cess, and ground rent. Office is directed to delete the name of Srimati Pratima Unnapur as the counsel for respondent number 1. Stop. Yes. Can you make that 62? Then the TV go down. Yes, Narendra TV nenne matter. Nenne ಯಾವತ್ತೋ ಬಂದಿತ್ತಲ್ಲ ಇದು ಇಷ್ಟರಮ್ಮ ನರೇಂದ್ರ ಡಿವಿ ಗೌಡ. Ian, what is it? But a suit was filed against whom? PM Kumpegowda. Ex parte decree, na?
I have produced copy of the parking RSA.
There's no representation for the petitioner. It is seen that even on the last date, the learned counsel for the petitioner sought and obtained time, obtained an adjournment. So the last chance, the petition against P1 is abated unto that. As a last chance, this one, even clear that if there is no representation on the next day, the petition will be dismissed for non-prosecution. Vani Sadashivaya.
Yes, my lord, I represent the connected matter, my lord. It's a matter where, my lord, the site was allotted to my vendor. After, my lord, I purchased the property. Kata was...
Shivraj Patil, Shivraj Patil. K. Vani and Prasad.
Even the matter was referred to the Lokayukta.
How many sites are formed? How many sites are formed? 412 sites are formed. Yes. This is a central scheme. This is a central scheme, isn't it? Central scheme of development of small and medium towns. Central scheme always. Central scheme, then what happened to the other sites?
This was led to the government, the
inquiry and it was found that the irregularities in the card. The report was submitted to the government. The government has constituted the inquiry committee. Direct committee, Mr. Ramnagar. And Assistant Commissioner Ramnagar, Deputy Director Land Records, Assistant Director Land Records, and both planning member. But all the records maintained by the municipality was submitted to the inquiry committee. But now the inquiry committee has submitted a report. I produced the document and connection of the affidavit of the Commissioner of the inquiry committee has recommended to them constitute agency page number 18.
Page number?
These are the recommendations of the committee.
Page number 18.
Page number 18. The affidavit right on 29.
ಇವತ್ತು ಎಷ್ಟಿದೆ ಸೈಟ್ಸ್ ಇದೆ 262 ಇದೆ. ಆಯ್ತು, when are you going to conclude this inquiry?
Inquiry committee, last if we start on page number 18, there are totally 7 recommendations of the inquiry committee. That is the first one. Over 55 sites with us to the allotment of this person, they have to be issued the Kata responsibility. And in respect of the area results of past state government, because the enclosures at 10 positions.
No, you have a plan. You have a plan. The plan is yellow. Plan is yellow.
Even according to the plan, the plan itself is tempered. So, when I got to the municipality has to get the original record from the RRT and it has to tally with the records available.
Don't tell me that you will not have plan, layout plan.
But the entire record is submitted to the local record also to the inquiry committee. I have to get back the record. Thereafter, the notice has to be issued to all the allotments of the state. They have to submit the original record. That records have to be.
ಈ ರಿಪೋರ್ಟ್ ಯಾವಾಗ ಆಗಿತ್ತು?
21 to 2022.
21 to
2022.
ಆಯ್ತು, ಈ ಎಕ್ಸರ್ಸೈಸ್ ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
So, government is submit ಮಾಡಿದ್ದಾರೆ. The government has to give direction to the municipality to proceed with the recommendation submitted by the inquiry committee, and thereafter the municipality will decide to issue data in respect of the bona fide allotments. That will take a lot of time, because in respect of all the sites, we have to verify with the original records of the municipality and also the records submitted by the allotments.
ಎಲ್ಲಿದೆ ರಿಪೋರ್ಟ್ ಅದು?
Next,
R3 ಇದೆ ಇಲ್ಲಿ. R4.
That is para 4 of the affidavit of the minister. The entire recommendation has been deleted.
ಈ ತನಿಖಾ ತಂಡ ಇದು ನಡೆಯೋದೇ ಇಲ್ಲ. ಇದು ತನಿಖಾ ತಂಡದ್ದು ಆಗಿದ್ಯಾ?
Page number 4 ಆದ್ಮೇಲೆ page number 5 is the report. report has been submitted to the government and also to the local. No whether the government has to issue direction to the municipality to proceed in accordance with the report submitted by the.
ಆಯ್ತು 55 ಸೈಟ್ಸ್ ನಿವೇಶನದಾರರಿಗೆ ಹಂಚಿಕೆ ಮಾಡುವ ನಿವೇಶನ ಕ್ರಮಬದ್ಧವಾಗಿರುತ್ತವೆ.
In respect of the remaining sites, the committee has given a recommendation at page number 18.
ಏನು ಇಂಟಿಗ್ರೇಟೆಡ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಏನ್ ನೋಡಿ ಕೊಳಚೆ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ ಅಂತ ಬರುತ್ತೆ. ಇಂಟಿಗ್ರೇಟೆಡ್ ಡೆವಲಪ್ಮೆಂಟ್
No municipality has the boundaries that the boundaries of the property acquired for this purpose and thereafter as not available. Once again, the credit has to be filed. They have to be given numbers and the area earmarked for are
ನಿಮ್ದೆ ಅಲ್ಲ ನೀವು ಅಲ್ಲ ಎಲ್ಲ ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಮಾಡೋದು ಇದೆಲ್ಲ.
the municipality is not in a position to state that.
ಅಲ್ವೇ ಮಿಸ್ಟರ್, ನಿಮ್ ಪ್ರಾಪರ್ಟಿನ ನೀವೇ ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡಿದ್ರಿ. ಯು ಅಲೋ ಪೀಪಲ್ ಟು ಕಮ್ ಅಂಡ್ ಸ್ಕ್ವಾಟ್ ಆನ್ ಯುವರ್ ಪ್ರಾಪರ್ಟಿ.
ಒಂದೇ ಸೈಡ್ಗೆ ಹೆಸರಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಲೆಟರ್ ಇದೆ.
ಅದೇ ನೀವೇ ಮಾಡಿರೋದು ಅದೆಲ್ಲ.
ಅದನ್ನ ಔಟ್ಸೈಡ್ ಆಫ್ ಇಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್. No matter the municipality has to look into the records submitted by the allottees or the purchasers of the property that have to be tallied with the records available in the municipality. Thereafter, if you found that correct site has been allotted to the resident person, then it will be a position to issue parliament. Otherwise, what happens that parliament will send the property to some other person. That creates a multiplicity of proceedings. Bona fide person will be
ಆಯ್ತು. ಇದಾದ್ಮೇಲೆ ಏನೋ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಏನಾದ್ರು ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿದ್ರ ಯಾವ್ದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಬೇಡಿ ಅಂತ?
government has not given any direction to municipality. As the what manner the municipality has to adopt the recommendations of the authority.
Yes, what is, when will you take a decision on this report? Yes. ಆಯ್ತು, ಜನಗಳು ತೊಂದರೆ ಆಗ್ತದೆ. The government should take a proactive measure immediately. Purple. The Joint Council for the respondents, respondent number, the Joint Council for the Municipal Corporation, Joint Council for the City Municipal Council, Chenapatna. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? ಮಂಗಳೂರುಪೇಟೆ. Council for the City Municipal Council, Chenapatna submits that the properties, that the sites in these petitions submits that the petitioners claim, submits that the petitioners in these petitions claim title in respect of sites which are allegedly formed by the respondent number 2 by the municipal council under the integrated development and small and medium towns scheme. He submitted that the said scheme, 470 sites were formed of 470 sites of various dimensions were formed, of which only 55 sites were allotted by the city municipal council, while there were 525 katas in the records of the city municipal council. He submits that on a complaint lodged before the Lokayukta, on a complaint lodged before the state government, the inquiry was handed over to the Lokayukta. The case was handed over to the Lokayukta for conducting an inquiry. Under section 7(2)(a). A complaint was lodged before the Lokayukta, which conducted an inquiry and thereafter placed its report. Inquiry under section 12. Section 9. Conducted an inquiry and submitted a report before the state government. Later, the state government, in terms of order dated 23/7/2011, had granted permission to the Lokayukta under section 7(2)(a) of the Karnataka Lokayukta Act 1984. Consequent thereto, an inquiry was held and the Lokayukta submitted its report. What is annexure R3? Annexure R3 in it. R3 is a dot. Chalakanda ante patti ಮಾಡಿ inquiry was held and the Lokayukta submitted its report. Inquiry was Anisha Tadi. Lokayukta inquiry ಮಾಡಲಿಲ್ವಾ? The report was submitted by the Lokayukta under section 9(2) to the director of municipality. But thereafter, the justice of the government had requested the Lokayukta for investigation and to take action. But the Lokayukta issued order after order section 7(2)(a) sanctioning the order to entrusting the inquiry to the Lokayukta. It is the state government in terms of an order. Submitted on a complaint lodged before the. He submitted that. There 412 sites ಅಂತೀರಾ? He submitted that there were several irregularities in the registers maintained in the office of the municipal council relating to allotment of sites, which resulted in complaints
before the Lokayukta and the Director of Municipal Administration. Full stop. Therefore, on the basis of a report of the Lokayukta under section 9 bracket 2, an inquiry committee was constituted by the government and the Director of Municipal Administration was directed to inquire and submitted. Full stop. During the course of inquiry by the technical audit cell attached to the Lokayukta and Superintendent of Police of Lokayukta, irregularities in the meetings of and other irregularities were found. Therefore, the Director of Municipal Administration submitted a report to the government with a request to refer the matter to the Lokayukta for investigation. Full stop. In the light of the report submitted by the Director of Municipal Administration, that the Government of Karnataka issued an order dated 23/7/2011, handing over the investigation to the Lokayukta under section 7 bracket 2 bracket A of the Lokayukta Act. Thereafter, the records relating to the sites formed and allotted and other records were handed over to the Lokayukta. ಇದೇ ಒಂದು ಅನಕ್ಷ R4 ಯಾವಾಗ ಆಯ್ತು? In the meanwhile, based on the report of the government had constituted a committee comprised of the Special Deputy Commissioner, Additional Deputy Commissioner, Assistant Commissioner, Deputy Director, Additional Director, and Planning, Director of Town Planning, who submitted a report to the state government stating that out of 470 sites formed, only 50 sites were allotted by the city. When 55 sites were allotted by the city municipal council, while there were 525 katas that were registered in the records of the city municipal council. He therefore submitted that for the council to take a decision until the state government takes a final call on the report and suggest the further course of action. Full stop. That way of the matter, this court deems it appropriate to order. This court deems it appropriate to direct the sub-registrar of Chenpatna. Then Chenpatna, sub-registrar of Chenpatna, as to direct all the sub-registrars in the district, in the Ramnagara district, not to register any document relating to the IDSMT scheme in Mangalwarapete, Kasaba Hobli, Chenpatna town until further orders. Full stop. The learned AGA, the learned HCGP is directed to secure instructions regarding the course of action that the government intends to take
pursuant to the report dated 21/2/2022, submitted by the committee. Yes, this is Monday. It's on Monday. ಈ 3 ಜನದ ಏನು 55 ಬರುತ್ತಾ? ಕರೆಕ್ಟ್. ನಿಮ್ದು ಎಲ್ಲಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು? ಯಾರು? ಆಯ್ತು, unless the government decides. ಆಯ್ತು, ಎಂಕ್ವೈರಿ ಅಷ್ಟು ಹೈಕೋರ್ಟ್ ಜಡ್ಜಸ್ ನಾವೇ ಫೇಸ್ ಮಾಡಿದೀವಿ. G category, I don't know whether you know about the G category sites. ಹೈಕೋರ್ಟ್ ಜಡ್ಜಸ್ ನೇ ಬಿಟ್ಟಿಲ್ಲ, ಮತ್ತೆ ನೀವೇನ್ ಬಿಡ? ಎಸ್, single conversion. This is regarding conversion. So what is the relief sought for? Yeah, what is annexure here? Local planning authority. ಬರೀ ಲೋಕಲ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅಂತ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ? ಹೌ ಇಸ್ ಇಟ್ ಜಸ್ಟಿಸಿಯಬಲ್? It has become infructuous because there's a local planning authority constituted for Mudvidri. Now there's already a master plan implemented. So master plans are implemented across all planning authorities. Yes. Please find out whether Mudvidrige master plan implement agide. RMP 2012 ಏನು ಇತ್ತು? 2012 RMP ಇದೆ ನೋಡಿ, Mudvidri. Interim master plan was sanctioned, and thereafter RMP 2012 is in force. Request of the council for appellant petitioner list on Tuesday. Yes. Withdraw ಮಾಡಿ. ಅಲ್ಲ, ಇದು ಯಾರ ಕೇಸ್ ಇದು? ಅಲ್ಲ, ಇದು ಎಂ ಶಿವಪ್ರಕಾಶ್ ಅವರು ಇದಾರ ಇದರಲ್ಲಿ? ನಿಮ್ಮ ಹೆಸರಲ್ಲೇ ಮಾಡಿಸಿದ್ರು ಅಂದ್ರೆ ಅವ್ರು ಮಾಡಿಸಿರೋದ? ಇಲ್ಲ, ಎಂ ಶಿವಪ್ರಕಾಶ್ ಅಂದ್ರೆ listed before any other court.
record ಬಂದಿದೆ compromise settlement ಆಗಿದೆ.
Yes, sir. Where is the settlement? R2. So what you mean? Petitioner has challenged actually Gina, petition has challenged the endorsement dated 22/1/2013 issued by the respondent number 2, respondent number 1, issued by the respondent number 2, refusing to register the name of the petitioner in the assessment register of the property bearing house number 10 or model house number 10 at third stage at Gokulam third stage, Mysore city, on account of a civil suit OS number on account of a pending civil suit in OS number 981 of 2012. Full stop. The suit was filed against Manjunath. Expera. The learned counsel for the petitioner submits that the suit in OS number 981 of 2012 was filed by MP Manjunath against the petitioner herein, and that the said suit was compromised, and that the said suit was compromised, in terms of which the petitioner has conceded to the claim of the said Manjunath, and therefore he has no subsisting right, title, or interest in the property in question. Full stop. In view of the aforesaid submission and in view of the compromise entered into in OS number 981 of 2012, nothing remains to be considered in this petition. Consequently, this petition is dismissed. Consequently, this petition is disposed of. In view of the settlement arrived at OS number 981 of 2012 before the Senior Civil Judge and KMFC Mysore. And does it survive, madam? Does it survive? Yeah, but why did you demolish it? Why did you demolish it, madam?
I'm laughing. It looks like shit.
Simply go and demolish it without any notice.
Your Lordship, I'm appearing on behalf of the petitioner, Lordship. I'm seeking a short accommodation.
Connection? E. Annexure D is the permission. Annexure C is the permission. Yes, Mr.
Lordship, I have to seek instruction from the parties. The advocate on record is Mr. A.K. Subaya and Sri S. Ponana. A.K. Subaya has passed away, Lordship, so I need to seek instruction from the parties. A short accommodation.
How short? When do you want it? The 2000 petition, Mr.
Please, Your Lordship, the advocates on record, one of them is a senior advocate now, and
That I know. When do you want it?
2 weeks, Your Lordship. 2 weeks.
Please pick a date of your choice.
8th June, Your Lordship.
Grand Council for the petition each time as a last chance response is 8th June.
Obliged. Obliged.
Memo for what, madam?
Subsequent to filing of this petition, the corporation issued notice to the petitioner to pay the improvement expenses under the new provision. Therefore, I have sent those notices with my colleague. Kindly accept that notice. As per that demand, the petitioner has to pay 65 lakhs 39,700.
He wants you to pay.
ಅದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಅವರೇ 65 ಲಕ್ಷದ 39 ಸಾವಿರ
He is saying that you are liable to pay interest at the rate of some for the period of 5/25/2003 to 20th August 2011.
ಹೌದು ಕರೆಕ್ಟ್. ಇವಾಗ ಒಂದು ನಾವು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ, ಅದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಉಳಿದ 65 ಲಕ್ಷ ಅವ್ರು ಕಟ್ಟಬೇಕು. ಕೈಂಡ್ಲಿ ಸಿ ದಿ notice dated 11/10/2018 annexure R2 ಅದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡಿದೀವಿ ಅಮೌಂಟ್ನ. ಆ ಇಂಟ್ರೆಸ್ಟ್ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಉಳಿದಿದ್ದ ಅಮೌಂಟ್ ರೈಸ್ ಮಾಡಿದ್ವಿ.
What is the effect of this order passed by this court in this 42015 annexure A? What is the
Yes,
effect?
we have accepted it. We have accepted it. We have paid that amount. Interest ಅವ್ರು ಕೇಳೋದನ್ನ ನಾವು ಇದು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ನಮಗೆ ಉಳಿದಿದ್ದ ಅಮೌಂಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ನಮ್ ನೋಟಿಸ್. That has not been challenged.
Yes. They say that they have deducted that money. Then what remains? You file a fresh writ petition if you are agreed with this demand.
Yes.
If you are agreed with the demand, you file a fresh writ petition.
ಆರನೇ ಪೇಜ್ ತಾವು ದಯಮಾಡಿ ನೋಡಿ ಸ್ವಾಮಿ, ಈಗ ಕಳ್ಸಿರೋ ನೋಟಿಸ್ ನಲ್ಲಿ ಅವ್ರಿಗೆ 16,95,000 ನಾವು ಡಿಡಕ್ಟ್ ಮಾಡಿ.
ತಾಳಿ ಗೌಡ್ರೆ
ಆಯ್ತು.
17 July. Yes, please.
Immediately this notice is issued on 11 October 18. Primarily, this is the demand of Province B, the corporation is about more. And you see, these rules apply only with effect from 17th of January 2007.
This court has taken cognizance of that, directed them to repay or refund. That they were just telling me. Careful. What is this short on you today? It's short on you today.
2018 ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಕಳ್ಸಿದೀವಿ ನಾವು ಅವ್ರಿಗೆ.
The petitioner, being the owner of the land bearing survey number 174/1 bracket D of Bilekkalli,
ಹೌದು,
Beguru Hobbli, Bangalore South Taluk, sought conversion of the land from industrial to residential use. To stop. This was followed by the imposition collection of betterment tax by the Bangalore Development Authority, which also granted permission for conversion. Full stop. In the meanwhile, the respondent number 2 issued a notice demanding betterment charges of a sum of rupees 17,66,205 and Kata transfer fee of rupees 6,795. Full stop. Since the petitioner already paid the betterment charges, he resisted the same. He resisted the demand of the municipal council, resistable. He paid the demand. He paid the amount demanded under protest, and thereafter filed WP.
One request. He has not paid the betterment charges to BDA. Change of land use cost payment ಮಾಡಿರೋದು ಅವರು. ಅವರು
BDA
ಹೌದು ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯೂಸ್ ಕಾಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡೋದು not betterment charge.
First time ಮಾಡಿದ್ರು. This is a land conversion of land use charges, right? No? Change of land use charges.
ಹೌದು
Next, and challenge the demand in WP number 42015 of 2003. Full stop. The requisition file was allowed in terms of the order dated 25/6/2009, and the respondents herein number one herein, who was
paid that cost on 17/8/2011.
who was the successor authority, comma, was directed to refund the sum of rupees 17,66,205 along with interest at the rate of 12% per annum. Full stop. This was unsuccessfully challenged in writ appeal 3677 of 2009.
ಇಲ್ಲ ಅದಲ್ಲ ಅದು ಬೇರೆ ಕೇಸ್ ಸ್ವಾಮಿ ಅದು
ಇಲ್ಲಿ ಆ ತರ ಹೇಳಿದ್ದಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ ಅದು ಬೇರೆ ಇಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ ತಾವು ನೋಡಿ ಅದು ಈ ಕೇಸ್ ಅಲ್ಲ ಬೇರೆ ಕೇಸ್ ಅದು
ಬೇರೆ ಕೇಸ್ ಅದು
ಹೌದು 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 ಯಾವ ಪೇಜ್ 33 ನೋಡಿ ಸ್ವಾಮಿ ತಾವು
of 12% per annum. Full stop. The respondents paid the said sum of rupees 17,66,205 on 20th of August 2011, but failed to pay the interest.
Correct.
Directed by this court. Full stop. Following this, a contempt petition was filed in CCC 165 of 2012, which was dropped by this court.
Subsequently, rule has been amended.
The petitioner has filed this petition demanding the respondent number one to pay interest for the period 25/4/2003 to 20th of August 2011. Full stop. Next paragraph. When the requisition was listed for fine hearing, the Resident Counsel for the respondent number one filed a memo stating that the interest payable to the petitioner is deducted from out of the property tax side,
ಎಲ್ಲ improvement charges.
From out of the improvement charges payable by the petitioner. And that is somehow rupees 65,39,750 is payable by the petitioner. Full stop. Along with the memo, the notice dated 11/10/2018 addressed to the petitioner is also enclosed. 11/10/2018 and a correction dated 11/10/2018 addressed to the petitioner is enclosed. Full stop. The Resident Counsel for the petitioner submits that if the respondent number one has already deducted interest from out of the improvement charges payable, he may not pursue this petition. However, he submitted that liberty may be reserved to challenge the correctness of the calculation made by the respondent number one before the appropriate. This petition is disposed of. holding that the petitioner, holding that the respondent number 1 has adjusted the amount payable by the respondent number 1 towards interest as directed by this court in WP number 42015 of 2003 from out of the improvement charges payable by the petitioner. Full stop. It is however open for the petitioner to challenge the correctness or the calculation made by the respondent number 1 while demanding the improvement charges from the petitioner. All contentions are left open.
Obliged. Obliged.
69 I pay for the respondent. Either it may not survive because we said that we are going to cancel, stop his business unless he takes a health license. It's in the year 2013.
It's taken a license, is it?
ಗೊತ್ತಿಲ್ಲ ಅದಾದ್ಮೇಲೆ ತಗೊಂಡಿಲ್ಲ ಬಟ್ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ವಿ ಹೆಲ್ತ್ ಲೈಸೆನ್ಸ್ ಇಸ್ ಮಸ್ಟ್ ಅಂತ ಹೇಳಿ. I mean, it's a yearly event. Every year he has to renew. Probably would have renewed all this. Yes.
There is no representation for the petitioner. The learned counsel for the respondent submits that the petitioner is bound to secure the license from the health from the
corporation.
Respondent
ಆರೋಗ್ಯ ಪರವಾನಿಗೆ.
Number 2.
Periodically,
and that the petitioner has not placed on record any material to establish that
one submission.
Such
is also BESCOM a party in this. I do not represent that.
Secured was obtained for conducting the business. Full stop. Since there is no representation for the petitioner, the same is discussed for not. ಏನಾಗಿದೆ ಈಗ? How does it matter? How does it matter? You are required to only comply the building bylaws. Then in compliance, you look at the photographs. Action. I think who has to ascertain that? Somebody has to ascertain that whether it is within permissible limit. So if you have already sold this property,
and even on another day, he can.
your submission. Nindeli. Our submission record dispose ಮಾಡಕ್ಕಾಗುತ್ತೆ ನಿಮ್ಮ petition na. You should confirm whether you still have subsisting right or interest.
Next, Karkoli. Not necessary, madam. The petitioner has sought for a writ in the nature of mandamus to consider the representation, to consider his representation dated 12/3/2012, bracket annexure E, by which he had complained against the unauthorized construction put up by the respondent number 3 in violation of the sanction plan. He has also sought for a writ in the nature of certiorari to quash the endorsement dated 28/5/2013, by which the respondent number 1 had indicated that the respondent number 3 had not violated the sanction plan and had not encroached into any portion of the property belonging to the respondent number 1. He has also sought for direction to the respondent number 2 to take effective steps to clear the road occupied by the respondent number 3. Next paragraph. When the writ petition was listed for final hearing, the learned counsel for the petitioner submitted that the petitioner has already disposed of the site owned by him, and therefore site owned by him, and therefore site owned by him will stop. At this stage, the learned counsel for the respondent number 3 submits that the property is thereafter sold to another person, and therefore the petitioner has no locus standi to pursue this petition, has no interest in it, has no interest to pursue this petition. Stop. In view of the above, this petition is disposed of. This petition is disposed of without disturbing the order passed at annexure M. It is, however, this will not come in the way of any other person challenging the endorsement at annexure M. Endorsement dated 28/5/2013 at annexure M. The subsequent purchase and subsequent purchase from challenging. Violation sitting here, we think that it is very what we call minuscule, but for a neighbor, for a person whose neighbor is constructing unauthorizedly, it becomes a pain for him to see every day. Every day it's a nuisance. Suppose if he blocks the passage of air and light, it's a perpetual nuisance. It's commercial marketing. But for persons who are facing the difficulty, correct? That is okay. Within 5%, nobody will object. 5% and the one sajja.
Even if you put an extra balcony, it will exceed 5%. Even if you put one balcony extra, it will exceed 5%. ಅದು ಮಾಡೋದು ಒಳ್ಳೆ ಉದ್ದೇಶಕ್ಕೆ ಫಾರ್ ಫ್ರೀ ಮೂವ್ಮೆಂಟ್ ಆಫ್ ಏರ್ ಅಂಡ್ ಲೈಟ್ ಇಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್. ಅದು ನಾವು ಏನೋ ದಡ್ರ ತರ ಏನೋ ಒಂದು ಸೈಟ್ ಫುಲ್ ಮನೆ ಕಟ್ಟಬೇಕು ಅಂತ we seem to have a grand idea of having a bigger space without having any common area. Yeah, it affects us all. I remember a lawyer coming to my office and he wanted to file a suit against another resident who used to bring his dog every day. And that dog used to urinate in front of the lawyer's house. On suit haki sir anta bandiru. Sir, the dog will urinate where it wants to. A person cannot force a dog to urinate at a designated place.
Injunction against a dog.
Injunction against a dog. So he came, he was so infuriated. ಮೊದಲನೇದಾಗ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ಅವ್ರ ಮನೆ ಮುಂದೆನೆ ಇದ್ ಮಾಡ್ತೇವೆ. Of course, when it rains, it stinks, no doubt. When it rains, the whole place stinks because of the dog's urine. ಏನ್ ಮಾಡಕ್ಕ ಪಕ್ಕದ ಮನೆ ಮತ್ತೆ ಗಾಳಿ ಬೆಳಕು ಬರೆದ್ರೆ ಅವ್ರಿಗಿನ್ನ ಎಷ್ಟು ಕೋಪ ಬರ್ಬೇಕು.
My lord, I am appearing for the petitioner in this case, my lord.
Yes.
My lord.
Yes, please.
My lord, in this petition, I have challenged the circular issued by the state government as at Annexure E, page number 27, my lord.
Annexure E.
Annexure E.
G.
E. E for elephant, page number 27, Swami.
Yes.
ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಅನಧಿಕೃತ ಆಸ್ತಿಗಳ ನೋಂದಣಿ ನಿಯಂತ್ರಿಸುವ ಬಗ್ಗೆ. In this circular, I have challenged particularly class 6, my lord. 6ನೇ ಕ್ಲಾಸ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, ಉಲ್ಲೇಖ 5ರ ಕಂದಾಯ ಇಲಾಖೆಯ ಸುತ್ತೋಲೆಯಂತೆ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳ ವ್ಯಾಪ್ತಿಗಳಲ್ಲಿನ ಆಸ್ತಿಗಳನ್ನು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ನೀಡುವ ನಮೂನೆ 9 ಮತ್ತು 11 ಆಧರಿಸಿ ಉಪನೋಂದಣಾಧಿಕಾರಿಯವರು ನೋಂದಣಿ ಮಾಡುತ್ತಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದುದರಿಂದ ರಾಜ್ಯದಲ್ಲಿನ ಎಲ್ಲಾ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳು ನಮೂನೆ 9 ಮತ್ತು 11 ನೀಡುವ ಸಂಬಂಧ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಈ ಕೆಳಕಂಡ ವಿಧಾನವನ್ನು ಅನುಸರಿಸತಕ್ಕದ್ದೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಿದ್ದೆ. ಯಾವುದೇ ನಾಗರಿಕನು ತನ್ನ ಆಸ್ತಿಗಾಗಿ 9 ಅಥವಾ 11 ಕೇಳಿದಾಗ ಸದರಿ ಆಸ್ತಿಯು ಅಧಿಕೃತವಾದದ್ದೇ ಅಥವಾ ಅಲ್ಲದೆ ಎಂಬುದನ್ನು ಪಂಚಾಯಿತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯು ಪರಿಶೀಲಿಸುವುದು. ಈ ಸಂಬಂಧ ಈಗಾಗಲೇ ಉಲ್ಲೇಖ 2, 3, 6 ಮತ್ತು 7ರ ಸುತ್ತೋಲೆ ಆದೇಶಗಳಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಆಸ್ತಿಗಳು ಅಧಿಕೃತ ಆಸ್ತಿಗಳಾಗಿರುತ್ತವೆ. 1. ಮೂಲ ಹಳೆಯ ಗ್ರಾಮ ಠಾಣಾ ವ್ಯಾಪ್ತಿಯ ಒಳಗಿರುವ ಆಸ್ತಿ ನಿವೇಶನ ತಹಸೀಲ್ದಾರ್ರವರು ನೀಡುವ ರಫ್ ಸ್ಕೆಚ್ನಂತೆ ಉಲ್ಲೇಖ 4ರ ಸುತ್ತೋಲೆಯಂತೆ. 2ನೇದು, ಬಸವ ಸಮಿತಿ ಯೋಜನೆ, ಗ್ರಾಮೀಣ ಅಂಬೇಡ್ಕರ್ ಯೋಜನೆ ಮತ್ತು ಇಂದಿರಾ ಆವಾಸ್ ಯೋಜನೆ ಮನೆಗಳ ನಿರ್ಮಾಣಕ್ಕಾಗಿ ವಸತಿ ಇಲಾಖೆಯು ಹೊರಡಿಸುವ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ HD 55 ರಂತೆ ಸೃಜಿಸುವ ಆಸ್ತಿ. 3ನೇದು, ಭೂ ಪರಿವರ್ತನೆಯಾದ ವ್ಯವಸಾಯದ ಜಮೀನಿನಲ್ಲಿ ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆಯು ಸಕ್ಷಮ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಬಡಾವಣೆ ನಕ್ಷೆ ಅನುಮೋದನೆಯೊಂದಿಗೆ ಸೂಚಿಸಲಾಗುತ್ತದೆ. So class 6 categorizes only these 3 types of ಆಸ್ತಿ as ಅಧಿಕೃತವಾದದ್ದು, ಆಥರೈಸ್ಡ್ ಅಂತ. ಅನ್ಆಥರೈಸ್ಡ್ ಯಾವ್ದಾಗತ್ತೆ ಅಂದ್ರೆ ಇದಲ್ದೆ ಈ 3 ಅಲ್ಲದೆ ಇರೋದೆಲ್ಲ ಅನ್ಆಥರೈಸ್ಡ್ ಅಂತಾರೆ. That is at class 11, my lord. Class 11 of this circular. ಆಸ್ತಿಯು ಅನಧಿಕೃತವೆಂದು ಕಂಡು ಬಂದಲ್ಲಿ ಯಾವಾಗ ಅಂದರೆ ಮೇಲೆ ನಮೂದಿಸಿದ 3 ವಿವಿಧ ಆಸ್ತಿಗಳ ಪೈಕಿ ಯಾವೊಂದು ಇದಕ್ಕೂ ಸೇರಿಲ್ಲದಿದ್ದಲ್ಲಿ ನಮೂನೆ 9 ನೀಡತಕ್ಕದ್ದಲ್ಲ. So therefore the categorized 3
ಹೇಳಿ, which are the other properties?
which are the other properties? And suppose if if I have constructed a house, or if I am having a site which has been left out to me under the ULC proceedings. Here, this is a case where I had the agricultural property.
Well, if it is left out of ULC proceedings, then also you have to get it converted.
My lord, such a thing is not required. I have produced a judgment of this honorable court. If it is already in the urban land agglomeration area, such a conversion is not required.
If it is within the municipal limits.
Yes.
If it is within the municipal limits.
Yes, my lord.
Then conversion is not required.
It is within the municipal limits is my respectful submission, my lord. Therefore, in respect of this very lands, this honorable court, as a annexure F has said, if it is within the municipal limits and urban agglomeration area, urban ULC proceedings, conversion is not required.
Conversion bekagilla. What about land, road, 20 feet, 10 feet roads?
Yes. Now, in this case, I am only having a site, my lord. I have not yet constructed. I wanted to sell this property. When I went, the sub-registrar, he said, no, you go and bring 9 and 11 from the PDO. When I met the PDO, he says, no, we will not give because you have not got this land converted. And you will have to bring a tahsildar in the Idin.
Where is that endorsement?
Endorsement orally has said, my lord. In fact, your lordship may kindly see annexures. Annexure A is the taxpayer receipt. Annexure B is the Kata demand register of Panchayat, and already Panchayat idrallide. Annexure B demand register and tax karta idine.
Where's your property, Mr.? Where's your property?
My property is serious site number 636 536/8. ಇದೆ ಈ ಮೂರರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಆಸ್ತಿ ತೆರಿಗೆ
ಮೈಸೂರು ಒಳಗೆ ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟ್ಸ್ ಒಳಗೆ ಬರುತ್ತಾ?
ಹೌದು, ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟ್ಸ್ ಒಳಗಡೆ ಬರುತ್ತೆ ಅನ್ನೋದು ಮೈ ಕೇಸ್ ಸ್ವಾಮಿ.
ಪಂಚಾಯತಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಪಂಚಾಯತಿಗಳು ಕೆಲವು ಕಾರ್ಪೊರೇಷನ್ ಲಿಮಿಟ್ಸ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಇದು ಲಲಿತಾದ್ರಿಪುರದಲ್ಲಿರೋದು ಸ್ವಾಮಿ. ಇಟ್ ಈಸ್ ವಿತ್ ಇನ್ 4 ಕಿಲೋಮೀಟರ್ಸ್ ಇಲ್ಲ. ಆ ಲಲಿತಾದ್ರಿಪುರ ಅಂತ ಹೇಳಿದ್ರೆ ಇದೆಯಲ್ಲ ಪ್ಯಾಲೇಸ್, ಲಲಿತ್ ಮಹಲ್ ಪ್ಯಾಲೇಸ್ ಪಕ್ಕದ್ದು ಸ್ವಾಮಿ ಇದು. ಸೊ ಅದನ್ನ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾನು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಕೊಟ್ಟೆ, ಅವರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು, ಏನು ಮಾಡ್ಲಿಲ್ಲ. ದೇರ್ ಆಫ್ಟರ್ ಐ ಹ್ಯಾಡ್ ನೋ ಅದರ್ ಆಪ್ಷನ್. ಏನಪ್ಪ ಸರ್ಕ್ಯುಲರ್ ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಈ ಸರ್ಕ್ಯುಲರ್ ನೋಡಿದ್ರೆ ಈ ತರ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್ ಈಸ್ ದ ಇಂಪ್ಯೂನ್ಡ್ ಸರ್ಕ್ಯುಲರ್ ಅಮೌಂಟ್ಸ್ ಟು imposing a ban on transfer of lands or the prevention of my property being transferred or sold, my lord. Such a thing cannot be done by means of a circular is my respectful submission. My lord, as per section 6 of the Transfer of Property Act, any transfer could be, any property could be transferred. That's what section 6 of the Transfer Act.
Property can be transferred, sir. No dispute about it. Any property can be transferred.
Yes, my lord.
Transfer can be regulated or not?
Its transfer could be regulated, my lord. Regulated only by means of a statutory law. Substantive law irbeku, but not by circular. Therefore, after my filing this petition, the state government echetkondo, they have issued the rules. I have amended the petition, my lord. Your lordship may kindly.
Sir, conversion bekagilla, I accept.
Swami.
What about the plan?
ಅಲ್ಲ ನಾನು ಮನೆ ಕಟ್ಟೋದಕ್ಕಲ್ಲ, ಇಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು.
ಲೇಔಟ್ ಪ್ಲಾನ್
ಲೇಔಟ್ ಪ್ಲಾನ್ ಎಲ್ಲ ಏನು?
You say that it lies within the municipal authority, municipal limits.
Yes, my lord.
If it lies within the municipal limits,
yes,
are you not required to obtain a plan of the layout?
ಇದನ್ನ ಸೈಟ್ ಆಗ ಮಾಡಿದ್ದಾರೆ, ಗ್ರಾಮ ಠಾಣ ಒಳಗಡೆನೆ ಇದೆ ಅಂತ. ದೇರ್ಫೋರ್ ಪಂಚಾಯತ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್
ಗ್ರಾಮ ಠಾಣ ಒಳಗಡೆ ಸರ್ವೆ ನಂಬರ್ ಹೆಂಗಾಗುತ್ತೆ ಸರ್?
ಇಲ್ಲ, ಸೈಟ್ ಇದು ಖಾತಾ ನಂಬರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸೈಟ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸರ್ವೆ ನಂಬರ್ ಅಸೆಸ್ ಕನ್ವರ್ಷನ್ ಆದ್ಮೇಲೆ ಗ್ರಾಮ ಠಾಣಕ್ಕೆ ಸೇರ್ಕೊಳ್ಳುತ್ತೆ
ಸ್ವಾಮಿ.
ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇರೋವರೆಗೂ ಗ್ರಾಮ ಠಾಣ ಅಲ್ಲ ಅದು. ನೀವೇನೋ ಸರ್ವೆ ನಂಬರ್ ನ ಸೈಟ್ಗಳು ಮಾಡಬಹುದು, ಇಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
ಮಾಡಿ ಇವರು ಗ್ರಾಮ ಪಂಚಾಯತಿನವರು ಡಿಮ್ಯಾಂಡ್ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಸೇರಿಸಿದ್ದಾರೆ ನಂದು.
ಸರ್, ಡೋಂಟ್ ಟೇಕ್ ಎನ್ ಆರ್ಡರ್ ಫ್ರಮ್ ದ ಕೋರ್ಟ್. ಕೋರ್ಟ್ ನಿಮ್ಗೆ ಒಬ್ರಿಗೆ ಮಾಡಕ್ ಹೋದ್ರೆ ಅದು ಇಡೀ ಇಟ್ ಓಪನ್ ಎ ಪ್ಯಾಂಡೋರಸ್ ಬಾಕ್ಸ್. The court cannot say that without a layout plan you can still issue katas.
My respectful submission.
Conversion ಬೇಕಾಗಿಲ್ಲ, fair enough.
Yes.
This is a law declared by the division bench of this court.
Yes, my lord.
But what about the layout plan? Should it not be sanctioned?
ಅದು ಲೇಔಟ್ ಪ್ಲಾನ್ ಮಾಡಕ್ ಮೊದ್ಲೇ ಸೈಟ್ಸ್ ಎಲ್ಲ ಮಾಡಿದ್ರು, ನಾವು ತಗೊಂಡಿದ್ದೀವಿ,
Therefore,
ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ, ಪಂಚಾಯತಿನಲ್ಲಿ ನಾವು ಟ್ಯಾಕ್ಸ್ ಕಟ್ತಾ ಇದೀವಿ, ಖಾತೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವಾಗ ನಾವು ಏನೋ ಮದುವೆಗೆ ಅದಕ್ಕೆ ಮಾರಬೇಕು ಅಂತ ಹೋದಾಗ ದಿಸ್ ಸರ್ಕ್ಯುಲರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್ ವಿತ್ ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಎಫೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಯಾವಾಗ ಇದು ಇಟ್ ಇಸ್ ನಾಟ್ ಬ್ಯಾಕ್ಡ್ ಬೈ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಂತ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿದ ತಕ್ಷಣನೇ ವೈಲ್ ಪೆಂಡಿಂಗ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ದ ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಅಮೆಂಡೆಡ್ ದಿ ರೂಲ್ಸ್.
That is why they call buyer beware. ಯೋಚನೆ ಮಾಡಿ ತಗೋಬೇಕಾಗಿದೆ.
ಸೊ ಇವಾಗ ಏನಾಗಿದೆ, ಈ ರೂಲ್ಸ್ ಆದ್ರೂ ಮಾಡಿದ್ದಾರೆ, ದಟ್ ರೂಲ್ಸ್ ಇಸ್ ಆಲ್ಸೋ ಕಾಂಟ್ರರಿ ಟು ಲಾ is my respectful submission. I have challenged that rule also.
Form number 9, if you look at, okay, let us go to form number 9 and Pudi. If you want an order on merits, we'll decide. The land revenue act. The principal Panchayati Act. Under what circumstances form number 9 and 11 is issued? Please take me through form number 9.
My lord.
Allow circular. Actually ಇರ್ಬೇಕಲ್ಲ.
ಆ ಸರ್ಕ್ಯುಲರ್ ಜೊತೆನಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ ನಮೂನೆ 9ಕ್ಕೆ ಏನೇನ್ ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಇದು ಅಂಡರ್ ದಿ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಆಕ್ಟ್, ಬೇಸ್ ಅಟ್ ಫಾರ್ಮ್ ನಂಬರ್ 11, that is 9 and 11. Land Revenue Act. Form number 9 and 11 is prescribed under which rule?
Under Karnataka Land Revenue Act, form number 9. Form of
that is different.
Adenu different ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
9 and 11 ಯಾವ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಸೋರ್ಸ್?
11 mutation register ಅಂತ ಬರ್ತಾ ಇದೆ ಇದರಲ್ಲಿ. ಯಾವ್ದು ಸರ್ಕ್ಯುಲರ್ ಏನೋ ಮಾಡ್ಕೊಡ್ತಾರೋ ಏನೋ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ ಇದೆಯಾ ನಾನು ನೋಡ್ಬೇಕು.
ಅಸೆಸ್ಮೆಂಟ್ ಆಫ್ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲಿದೆ?
ಅಸೆಸ್ಮೆಂಟ್ ಆಫ್ ಪ್ರಾಪರ್ಟೀಸ್
ನಂಬರ್ 9 and 11 ಇಂದ ಬೆಂಗಳೂರಲ್ಲಿ ಎಷ್ಟು ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಿದೆಯಲ್ಲ ನಿಮಗೆ?
ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ, ಎಲ್ಲ ಅದೇ ಕೊಡ್ತಾರೆ. ಯಾವ್ದು?
Please come to section 199. The whole of Bangalore is destroyed because of this form number 9 and 11.
Form number 9 and 11. Section 199. ಟ್ರಾನ್ಸಿಷನಲ್ ಪ್ರಾವಿಷನ್ಸ್ ಅಂತಿದೆ ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್. Section 199.
Provision Allah, sir. This is levy of taxes, rate, etc. by the Gram Panchayat. Nodi, within the limits of the Panchayat area, not subject to agricultural assessment. In the agriculture land, how do you say that it is Gram Tana? Find out from where this form number 9 and 10 are prescribed under which law. Please find out. Request of the council for the response. Next week on this. Yes, please.